Casey's show, and then there's some people here that want to ask a question. If the person that wanted the question couldn't come, we have some volunteers from Real Women in Trucking that are going to ask the question, or I might read it from what I have, and then the lawyers also have a copy to take with them of those questions. If you have a question, just raise your hand and let us know. If you want coffee or water or tea or refreshments, go help yourself right now and get comfortable. We have Paul Taylor and Peter Lavoie, is it?
Yes.
From the Truckers Justice Center. A lot of us have heard of the Truckers Justice Center. And Mr. Aronson is getting comfortable. He's going to sit down, and he focuses more on sexual harassment, and I'm going to let them tell you about their areas of law more. There's a couple people that have to leave early because they have other responsibilities here at GATS, so I'm going to let them do their questions first, so a little out of order, like if you would at a regular thing, just because everybody's trying to do a lot of stuff. So very quickly, Paul, do you want to just tell us a little bit about Truckers Justice Center?
My name is Paul Taylor. I am principal.
Let me say one more thing. We don't have a microphone system, and some of you have microphones, so make sure you talk really well. And James at Texomatic Pictures is going to be filming this as well. So
We're on, right?
You're on.
Okay. Well, okay. I've been a trucking lawyer for 32 years, which is my entire career. I grew up in the trucking business, and you'll forgive me, but I will state that I used to be a dispatcher, and I went to work for another trucking company and supervised dispatchers while I went to law school at night and started my law practice. And right off the bat, I was representing drivers, but I also represented trucking companies for the first 10 years of my career. I did not do employment law then. When it came to representing drivers, it was generally collection work for owner-operators, tickets, things of that nature. And I had a life-changing event. First of all, President Clinton helped change my life when he got rid of the Interstate Commerce Commission in 1996, which wiped out about 90% of my law practice. And I was attempting to figure out what I was going to do, and I thought, who needs a lawyer with knowledge in the trucking business? The carriers got lots of big buck lawyers, and shippers got their big organizations and their lawyers. I thought, well, maybe drivers need somebody. So I kind of stumbled and tried to figure out what I was going to do exactly. And I received a telephone call that changed my life. It was a lady named Daphne Iser called me. And she related to me a story about how her son Jeff and 4 friends were on the side of a road changing a tire, or they had some sort of car trouble on a turnpike in Maine. And a Walmart driver who hadn't slept for 2 days had falsified his logs, ran them over, and killed at least 4 of the 5 of them. And she started a group called Parents Against Tired Truckers, which was often perceived as an anti-trucker group. But what they did is got me involved in representing drivers. It gave me my first 2 referrals of drivers who get fired because they refuse to drive in violation of the commercial vehicle safety regulation. So a lot of what we do is we do general employment law for drivers, but about 80% of our work consists of representing drivers who get retaliated against because they won't break a commercial vehicle safety regulation, or they make safety-related complaints. That law is called the Surface Transportation Assistance Act. We do that throughout the country. The other thing we do, a good chunk of our work involves representing drivers prosecuting truth in leasing claims, which govern, there's laws that govern the content and compliance of mandatory terms that must be in a lease between an owner-operator and a trucking company. It does not protect you from your own ignorance in doing a stupid lease purchase. Okay, so if you want to go upstairs and sign a lease purchase and it's a bad business deal for you, we can't help you from your bad business deal. So that's the second principal area that we do. Third is we deal with DAC reports. If there's a Fair Credit Reporting Act which requires the DAC reports that the reporting agency higher right can do its best to ensure maximum accuracy. And there's rights, it's governed by the Fair Credit Reporting Act, even though it's a consumer report. So that's the third principal area. And the fourth, we do a lot of general employment law for drivers. If they call and say, I failed the drug test, they refused, what can I do? The answer is usually we can do nothing, but sometimes we can. So that's what we do, and I would say about 98% of our clients are truck drivers. We also have done some other general employment law. We were counsel in a class proceeding. EEOC turned it into a class called Deanna Roberts versus Prime, where Prime was found to have discriminated against in its hiring practices against women in employment, in hiring them, and the EEOC found merit in standing as counsel for our clients, and shared a lot of their work with the EEOC, and we obtained a very successful award for our client under Title VII of the Civil Rights Act for discriminated against because she was a woman. So that's what we do. I went a little long, so I'm sorry. I'm trying to be shorter.
Okay. All right, Mr. Aronson.
Well, thank you very much, Desiree. It's a pleasure to be here. I just flown in from New York last night, and I'm excited to be here. I'm here as a representative of Ackerman and Tilligeff, a law firm in Los Angeles that's really at the cutting edge of wage and hour class actions for truck drivers, particularly the abuses that go on where unpaid rest breaks and misclassification of drivers as independent contractors, owners and operators. Also, the piece rate system of pay, which is a method in which trucking companies can deprive drivers of a whole series of payments that they should get paid. And it's essentially works that when you're not driving, you're not getting paid for work, even though there's an awful lot of on-duty, non-driving work. As you all know, whether it's waiting time, detention time, paperwork, inspection time, and lots of other things. So that's a way in which really a company can get 14 hours of labor and pay for 10 hours only when the wheels are turning. And there's also a whole two other areas of concentration in terms of the wage and hour, which we'll get back to a little later, which are the fraud cases for the schools that try to provide training and make promises of what the drivers can make, and misrepresent or omit to inform drivers that while they are promised to make easily $45,000 or $50,000 a year, that's a gross figure. That does not talk about, that is before expenses, and the expenses of maintaining the truck and insurance and gas and all that can often lead a worker to netting out $17,000 a year, or sometimes even working below minimum wage, because in order to make that kind of money, the money that's necessary to live, the driver is working 80 hours a week and just eking out a bare minimum wage, if that. And then there's just the fraudulent, deceptive practices of what the schools represent in terms of charging fees, which are deducted from paychecks, and then providing very little. It can be nothing more than on-the-job training, and then they're locking the drivers into these commitments with a rule or a contractual agreement which says if you leave early, you still owe us this money. And so even though it's an abusive environment, the drivers cannot leave, or they feel they can't leave, and if they do, then they can saddle with debt. And Ackerman and Tilligeff are at the cutting edge of this, and I'll talk a little bit about that later. And Greg Ackerman and I worked together many years ago on a really exciting case that was the largest sexual harassment case ever brought in the United States without government involvement. And I just should take a second to tell you, do I have a second?
Yes.
All right.
You have more than a second.
May 1st is Labor Day in the Latin world. And in 1998, a major Fortune 100 company, a household name like Prudential or IBM, I won't say the name of the company, I'm not allowed to, but it issued a memo, and the memo was about workplace cleanliness, keeping the floors clean and garbage, etc. Two-side memo. Most of the workforce was Spanish-speaking, immigrant laborers, all documented in a warehouse out in the middle of a suburb. And one side was in English, the other side was in Spanish. And the English side had said, to the employees. The Spanish side had said, todos los animales, to the animals. And the Spanish workers got this memo, which was signed by the president of the facility, and they said, finally, we have proof. After 15 years of being treated like animals, now we have proof. And the company, they stormed the executive offices with the memo. The company got frightened and tried to get back all the memos, closed the doors of the company, shut down the copying machine, shut down the fax machines. One guy snuck out, called his wife on a cell phone and said, Mi amor, necesitamos abogado. Honey, we need a lawyer. He opens a Yellow Pages, finds a lawyer. Next day, the lawyer meets them 75 workers in front of a neighboring Kentucky Fried Chicken, signs them all up, and starts to bring this big case against this major company for racial harassment. Unbeknownst to them, that lawyer had no money, no office, no help, and was being investigated for stealing from clients, and was about to be suspended. And so they all, these poor workers gave this lawyer $500 each, which was a lot of money to each of them, and the lawyer took the case and all tried to settle it, and where he would get $1 million and the workers would get $10,000 each. And all of these workers didn't speak English, they didn't know their rights, except one family who had been there for 20 years, had children who were 19 and 20 working there, who were going to college, and they spoke English. And they, in their developing English, wrote to the judge and said, please don't call and close the case. The lawyer is not being transparent, and we want a second chance. And somehow, I know how, but they found me. As it turned out, the case was not about that memo. The case was about widespread sexual harassment against women in this facility. And supervisors would walk around openly and saying, aquí no quiero ni gorda, ni fea, ni vieja, ni prieta. Here, I don't want any old ones, any fat ones, any black ones, or any ugly ones. Solamente bizcochito, just little biscuits. And this was open, besides which there was touching, there was pressing pelvis, supervisors pressing their pelvis against the buttocks of women, and there was the demand for sexual favors in return for more overtime and the promise of full-time employment for temp employees. This became a very large case with 150 employees. It was not a class action significantly, which I'll talk about more in a moment. And after 3 years of litigation, it resulted in a very, very big win for the workers with life-changing money for these workers. So we have done, my firm, Aronson, Ditmar and Carbon, has done groundbreaking work in the sexual harassment field and in the wage field as well, but not in the trucking industry, although now with Craig, we're moving into that. I just want to take a second now, if I can. Did you want to continue, or did you want to move on to another phase? Because I want to speak a little bit about sexual harassment.
I do want you to talk about sexual harassment. The only person I know that Les, do you have a moment? Or
If he's got, I can get 10 minutes before I leave.
I'll do it in 8.
Thank you.
Okay. Okay. You know, sexual harassment, relatively speaking, in terms of the development of American law, is fairly new. It really came out in the 90s. You know, it always strikes me that for anyone who's a fan of musical theater, there's a show called How to Succeed in Business Without Really Trying, which was a sort of a parody of corporate America in the 60s. And there's a song in that show, which is very tongue-in-cheek, where all the men there get on stage and they say, you know, elbowing each other, a secretary is not a toy, no, my boy, not a toy. And it's all about the fact that one of the perks of having a secretary is that you can harass her. And that was kind of accepted. If you watch Mad Men, that show, you see that environment where you think if you're a boss, you can expect favors, sexual favors from your female subordinates. And over time, in the 90s particularly, the law started changing, and as a creature, as a subset of gender discrimination, the concept of sexual harassment was accepted by the courts. And just very quickly, there are 2 types of sexual harassment. There's quid pro quo, which in Latin means this for that, which is an exchange, where a boss says, you want to become full-time, you want to get a raise, you want to get a better job, you want to get a better assignment, sleep with me. Or some sexual act, or some sexual arrangement. That's quid pro quo. When that happens, particularly if it's a supervisor or someone with superior or a superior status than you, the company is liable. If you say no and are fired, or if you feel pressure to submit to that advance and can prove it, and it's someone with power over you, that act in itself, if it's quid pro quo, a company is liable. The more prevalent type of sexual harassment, though, the ones that are coming up now in the trucking industry, and there's some very exciting news in this area, are hostile work environment cases. Probably most of you have heard that phrase, a hostile work environment. So, again, when I say relatively recent, it's about 30 years old, the concept, maybe 25, where at an environment, the terms and conditions of your employment, which is sort of synonymous for environment, or at least the conditions of your employment, are rendered hostile or uncomfortable or intolerable because of your protected status. Here, it's usually women. But there are sexual harassment cases, and I've had many where men are the victims. And it's the idea that because of the conduct of the harasser, you are made to feel deeply uncomfortable, and your environment is materially changed at work. Now, harassment takes on many forms. The most egregious is physical harassment. And in the trucking industry, unfortunately, there are numerous incidents of sexual touching, even rape, forced sex, other kinds of touching, slapping the buttock, slapping the thigh, and you can imagine a whole range of touching. After that, verbal harassment. Comments about directly, and this is significant. In the hostile work environment case, the harassment does not have to be directed necessarily at you. If you are aware of it, meaning if you're, think about an assembly line, and if the boss is coming along and constantly putting his arms around the woman sitting, standing in the line next to you, and you're there for weeks or months saying, when is it going to happen to me? I'm next. Your environment is rendered hostile. And so one of the weapons in a hostile work environment is what happens to other women who are similarly situated is relevant to you. And that gives your case a lot of power, because the environment is now the focus of the litigation, not the individual plaintiff, the environment. And crucially, and this is going to come up in a few minutes, in a groundbreaking case that just came out a few months ago against CRST, a class of women were certified, a class action in sexual harassment, which is very rare, because the focus was on how the company responded to the complaints of harassment, not the individual incidents. Okay, so you have a hostile work environment, and really the elements there is first you have to establish that there was sexually offensive conduct. You want to also establish company liability. How do you hold a company liable? See, companies said, and this came up about 20 years ago, look, IBM, 30,000 employees. If Supervisor Jones in Toledo, Ohio, touches Miss Smith, why are we responsible? That's a rogue employee. We have a policy that says it's against our policy, and we have a complaint procedure. Why should we be responsible for that? We fired him when we found out about it. No liability. And the court said the following. This is the famous Farragher-Eller decisions, which created a whole dual affirmative defense for companies. First, if a supervisor uses his or her power to harass an employee and uses the power to fire, reduce pay, transfer, assign, uses some element of company authority and power to affect the employment relationship, the company is liable, because that supervisor is acting as an agent of the company and using the company authority to advance the harassment. But if there's no what's called tangible employment action, if there's nothing affecting pay or job status or assignments connected to the harassment, it's just physical or verbal harassment, it's just environmental harassment, can the company be held liable? The answer is yes, but the companies have a dual defense. And here's really where the meat of these sexual harassment claims, and particularly in the trucking industry, really is, which is, can they sustain those defenses? The burden of proof in these two defenses, the Farragher-Eller defenses, is on the company. And the defense is, did they take reasonable measures to prevent and correct harassment? Prevent means simply, really in most cases, a paper policy. They had a policy that said it's against sexual, we don't tolerate it. And they have a complaint procedure, where to go. And then the second is correct. Did they take prompt remedial action? And that's really where the action is. Let's go for the defenses now because I'm there, and then I want to go back to something else about what women can do individually and what they should do. So, if they had a paper policy, what did they do with the complaints? Did they respond? Did they investigate? I don't have time, but I can tell you, I've examined many human resources officials from major companies, I mean, who completely mishandled an investigation. I had a case against an international security company, and they didn't even examine the complaining party. They didn't question them in person. They did it over the phone. And then when I asked for the notes of the investigation, which obviously you have to document these investigations, they didn't have them. They lost them. So, I mean, how a company responds to a complaint of sexual harassment is critical. Did the employee complain? Now, it's not so simple. The companies say, no complaints, no harassment. If you didn't complain about it, it didn't happen. Just a general rule in the harassment world, and in the employment law world, they say, if it's not in writing, it didn't happen. Because if the he said, she said, or he said, usually is an obstacle. If it's just a single person's testimony. I've overcome that. It takes a lot of work. It takes a strong plaintiff. This is particularly a problem in the trucking industry, in sexual harassment. Because unlike most employment settings, whether it's a restaurant, or a store, or an office, where there are other employees around, typically in the trucking setting, it's one woman and one driver, or one woman and one man in a truck. And so it's really just he said, she said, with no one else around. And I just want to read something which is incredible. In this Sellers case, which is the case out of Iowa in March 2017, one of the reasons why the court there granted class action status to over 100 women who had alleged sexual harassment, again, which is very unusual. The reason why it's so unusual is, unlike a wage case in which everyone is saying, I don't get paid for rest breaks, and it's the same policy. If 100 different women claim sexual harassment, it's usually there are differences in what occurred. There are differences in harassment, there are differences in the complaints, there are differences in the proof, and so courts say, how can we certify a class that has 100 different claims? It's not susceptible, or it's not conducive to class treatment. They're all different. There are too many individualized differences, is the language of the courts. The lawyers for the women, one of whom is a fellow alumnus of mine from Columbia Law School in New York, and I know Josh Friedman, they were very smart. What they did is they said, and we did this in our case against that big company, instead of making it about putting the women on trial, we put the company on trial. And there they said the focus is on the company's failure to respond to complaints. And this was one of the first point the judge seized upon was that because of CRST's policies and procedures, it was essentially, they made it impossible for the company or the women to corroborate complaints. So here's a question that the lawyer asked, I think the head of human resources of CRST. Question: if the allegations of harassment concern behavior that occurred on the truck while the drivers are there together, would it ever be possible for you to find that harassment was corroborated based on evidence other than a third-person eyewitness who was on the truck seeing harassment? Answer: not unless there was an admission by the accused individual. So, if a woman comes and complains about harassment on a truck and there's just the woman and the male driver, there's no possibility of corroboration, the company is saying, unless the driver admits it. Now that's incredibly bad and incredibly unfair. What about the company's duty to do an investigation to find out, has anyone else ever complained? To ask other women what their experience was. What about interviewing the complaining witness herself? I find, in the way I found this to be a very effective tool, is the power of specificity. If a complaining party can tell you in great nuanced detail about who, what, where, when, how, of what occurred. You know, we all know, if you think about, as a parent, a 16-year-old child comes in at 4 in the morning and the parent said, I want you home at midnight. And they give you a generalized excuse. Oh yeah, I was out with a friend. Where? Well, a party. Where? Oh, some party. And it's vague and kind of, unspecific. Chances are the person's lying. If they come in and they say, well, You'll never guess what happened. You know, Nancy, my best friend, she got drunk and she threw up, and she threw up all over her clothes, and she couldn't go home because her mother would see. So we had to go to Debbie's house, and she had to wash the clothes, all of a sudden, whoa! I don't think my kid can make that up. I've had defense lawyers tell me, after cases have settled, Steve, we read your complaint, and we said, you can't make this stuff up. So the company, they just abdicated their responsibility to say, unless we have a driver admission, we can't corroborate. Well, maybe the only corroboration you need is a thorough interview with the complaining, and to look that person at the eye and see the truthfulness. And very often, you see someone who's talking from the heart, and I've seen many times tears rolling down his or her face because of their experience, and those tears are the marks of truth. So they found that there was an absence of corroboration of complaints, and that was a systemic failure. Just to quick other examples, they found that there was a failure to impose discipline on the harasser. Very often all that happened was the harasser was assigned to male-onlys trucks, systems. So they permitted to continue, and they just switched for a short period of time. That's systemic. That applies to many drivers. The driver managers also showed they were proven to tolerate harassment and failed to act. The complaints were made by women to driver managers. They did nothing for months, sometimes longer. And that failure of the driver managers to act was also a systemic failure. This happens all the time. There's the harasser, and then there's the complaining party. The complaining party is removed from the workplace. Unpaid suspension. The harasser is permitted to stay. Very unfair. It's a setback for the complaining party. And again, the court found that this was done on a broad-based systemic basis, not about the individualized case, about the company's response. Transit and lodging costs, if they moved it. The woman calls in the middle of the road and says, I'm in danger. They make her stay at a hotel and travel. They'll pay for it, and then they deduct it from the paycheck. Again, imposing a monetary cost on the complaining party. Across the board, systemic, and that was found to have been a basis for class certification. And then what they do is often they say they're going to extend the student driver training period because the student is removed from the lead driver's truck, and now she's got to go back and start again, and that's less money for her. She's not making money. Again, punishing the accuser. But the key is all of those 6 points are what the company did, and they found that that was systemic, broad-based, and therefore on those common questions a class could be certified. You don't need a class necessarily. I've handled cases with 1 plaintiff, 2. I have one now with 6, 23, 27, 150. I will just say one thing for women out there. 2 is not just two women suing or 2 people complaining is not just twice as effective as 1. It's a multiplier effect. I know personally from defense lawyers, whenever there's more than 1 person, it's a much more difficult case to defend, and the companies get much more frightened. I've seen insurance policies from insurance companies who insure against these kinds of claims, and whenever it's 4 women or more, it's considered a mass or class case, because companies know if you have 4 women or more, it's a problem. And so what I would say to women out there, keep your eyes and ears open. Very often, the harasser is a repeat offender. I've seen that over and over again. And if he's harassing you, he's harassed someone else, or he will. Talk to him. And whether it's in person or perhaps through social media, be careful with what you put on social media, but nevertheless, you can reach out, you can find either directly or through friends and colleagues, and you'll be surprised how people, have knowledge. And once you have that, you're off to the races. 2 last points. Complaints often are put on the employee as an obligation. Not so easy. It's embarrassing. Most people are afraid to complain. They're afraid of the consequences. They're afraid of retaliation, criticism, ostracism, blacklists, things like that. So the Equal Employment Opportunity Commission has come out and said, even though the failure to complain can be asserted as a defense by the company, there's two reasons that have been recognized by the courts why the failure to complaining should not be fatal. One is fear of retaliation. If you can show that you have a bona fide legitimate fear of retaliation, then your failure to complain can be excused. If you can point to a prior incident in which someone's complaint resulted in them being not just fired, prejudiced in some way, maybe having to repeat the training or other things, a poor assignment, that's a reason to be excused from not complaining. The second one, which is interesting and I think really applies in the trucking industry, is futility. If you can show that you had a reasonable basis to conclude that a complaint would be futile because you knew it'd been going on forever, nothing's ever done, even when people complain, the harassment continues, you are excused from complaining. And I've had success in cases overcoming the defense. We never got a complaint by showing it was futile and there was a fear of retaliation. There's more to say on that in range an hour, but I think I'm getting close to 8 or 9 minutes.
Time is up. I think sexual harassment to me, as a company owner, is very, very subjective. Very subjective. To say you look beautiful today, you could actually manipulate that into a sexual harassment case, where it's so the threshold of you as an attorney, the burden of proof is very, very low for you. So me as a jurist would be setting on that, and the scale is already in the defendant's favor. It's your burden of proof. So sexual harassment is very, very subjective. So I think opposites attract, and it's just human nature for that to happen. Going overboard, I don't think that you're beautiful or you look beautiful today, or it's all a choice of words. You look nice today, or you look beautiful today. So now we've just had a step from nice to beautiful, right? So at what point between nice and beautiful does the sexual harassment come into play? So that's a very fine line that us as companies have to operate under. And when you start looking at employment law, I mean, we're just hammered and hammered and hammered. And there has to be some type of common sense, you know? He rubbed me, or he rubbed me with his buttocks while I was getting coffee. Well, on my buttocks. I mean, it's so subjective. So I think that attorneys, and nothing against attorneys, because attorneys are there for a purpose, but I think it goes way overboard. And like you were saying before, all depends on how broke the attorney is. So I think it's very, very subjective. Any sexual harassment case, to me, going into and sitting on a jury, the defendant, the scale is weighted in his favor from the get-go.
The Supreme Court of the United States and courts throughout the country have agreed with you and have responded this way. The standard is harassment must be severe or pervasive. Severe means really bad, and it can't be beautiful, it can't be nice, it can't even be sexy. Hey, you look sexy. It can't be. No, it has to be something. Severe is egregious. It has to be bad. Or pervasive, which means frequent, regular. And so I can tell you now, cases are dismissed all the time for the kinds of conduct you described. And even before they get dismissed, most lawyers that I know would never bring those cases. They wouldn't even bring it for that kind of conduct. Right. And so, because the likelihood of success is non-existent essentially. So when it comes to that, and beyond that, the standard isn't just severe or pervasive. It has to be what a reasonable person, not what Janet Smith experienced or thinks, what would a reasonable person who experienced what Janet Smith experienced react, or how would they perceive that conduct? And so, slight petty insults are not enough. But if you have severe or pervasive, and when you have, for example, a serious act of touching, right? That in and of itself could be not brushing buttocks to buttocks, getting coffee, but something intentional, deliberate. I'm talking something, really crosses the line, and everybody knows it. That would be enough. But you have a point, and the courts have responded.
I'd like to follow up on that point. We had a case where a female trainee was raped by her trainer for a major trucking company whose name you would know. Sometimes I use names if it goes to decision, but a lot of settlement agreements have confidentiality clauses in it. She was raped by her trainer in the parking lot of Lowe's. Now, that definitely was serious touching. We lost at the Equal Employment Opportunity Commission. EEOC is a sort of like a step through which we all have to go. There are a lot of bad cases out there, but the win rate, and Mr. Aronson may agree with me, but the win rate at EEOC for discrimination cases, where it's race, religion, age, whatever, is about 3%. So it's not like people file these cases and then somebody writes them a check. We have a lot of steps to go through, and good lawyers don't take cases where somebody says, hey, beautiful, how you doing? Once we get past EEOC, we get a right to sue letter. Then it goes usually in the U.S. District Court, and there's a procedure called summary judgment. In the employment, in the federal courts of this country, in employment cases of all types, employment discrimination or harassment type cases, race, religion, age, sex, the win rate on a summary judgment, which means, hey, is there enough here to go to trial, enough of a material fact dispute? Employers win those motions at about 75%. So it's not like we have to have a really good case if we're going to win it, because we have to win it at all sorts of levels. And most of those cases get appealed then to the circuit courts. So it's like, so I don't think that those cases, the so-called frivolous case, I don't know, it could be, some lawyer in need of money, and some employers will just write a few $1,000s, but I don't see that. I don't get called with a lot of frivolous cases. When I get them, I shouldn't say it. We get somebody, somebody said something to me, looked at me sideways, or, made a joke about me being black, or, called me beautiful. So I said, big deal. Let it go. Go find somebody else. But by the way, here's your deadline for filing the news.
Just switch gears because I have to leave. There's been a lot of interesting topics that have been brought to our attention. One is inward-facing cameras of a driver. Is an inward-facing camera 24/7 an invasion of privacy?
No. Well, I mean, maybe, but this is your workplace. Employers have a right to make bad decisions, to have an environment, workplace that you don't like, so long as it doesn't violate a specific employment. In every state of this country, with the exception, I think, of Montana, we have at-will employment, which means they get to make the rules short of violating a specific law passed by state or Congress. And I'm not aware of any law. This is your workplace. I mean, I don't like it. I could see where a driver wouldn't want to work for that, but the courts are not HR departments for companies. So I would say, yeah, no, it's not an invasion. It's their truck.
What if it's not a right to work state?
The right to work state means you can't be compelled to join it. Okay? You mean in an at-will employment
Yes.
state? Well, there's only one of those, and that's Montana.
Okay.
So I don't know what Montana law. And Montana it's sort of like your at-will employment for a certain amount of time, and after that, you no longer are. They have to have a cause. So, no, I mean that. I don't like it, and I can see where drivers wouldn't like it, but this is their truck. They have the right to put a camera in it. UPS monitors everything. They got cameras everywhere. I don't think they got them in the bathroom.
Let's kind of attack it from an over-the-road driver standpoint with the sleeper berth, because we've got brains enough that if we address the more difficult of the two, a sleeper berth day cat. So I've got a sleeper berth. Now, if I'm an employer, I cannot have cameras in the bathrooms, but I can have a camera outside the bathroom door. I cannot have a camera in a changing room, but I can have cameras outside the door again. And that way, if somebody's carrying goods in, or they bringing goods out, or they steal it, there's all kinds of reasons, you know, but there's that line of privacy there. Now, I've had drivers say, oh yeah, the rear-facing, and I'm not anti-rear-facing camera, by the way. The rear-facing camera, the light comes on, well, close your curtains. They don't provide me curtains in the truck to close, you see? So that does a red bell up. So my way of thinking, and you're right, I like what you said, is a drivers are, oh, it's your home away from home. No, this is a workplace. This is your workstation. No different than having a restaurant with bathrooms, you know? This is what they're brainwashed to believe. You're not at work.
What's the question here, Phil?
Casey Phillips submitted one along this line, so maybe this is from Mike, that says inward-facing cameras, what is a company-owned equipment right, and what is the driver's legal right to decline a truck with this equipment?
Driver has a perfect legal right to decline the truck with that equipment. When he does that, the employer has a perfectly legal right to fire him for declining the equipment. You agree? Yes.
Okay, so, but drivers are paid by the mile. Therefore, they are, let's look at it this way. If I'm driving, I'm being paid, the camera can be on. But once the truck stops, shouldn't the camera go off? I'm no longer being paid. Why are you supervising?
You're in their vehicle. You're in their vehicle. I'm not, I mean, don't get me wrong, I'm
No,
not
I'm with
advocating that
you.
they do this or that you work for companies that do this, but it's their vehicle.
So the drivers, and like I say, I'm not anti-rear facing. Drivers have
Well,
this
I am,
attitude,
but
that's
I mean,
my
I- you
home
know, if
away
I was a
from
driver, I
home,
would drive for
blah, blah, blah,
somebody.
blah. Who are they? That's my space, this, that, and the other.
Do you?
And like you say, it's a company vehicle. So what about a team truck? Well, obviously it can run non-stop. What we're told about these cameras, and this is all a scam, it goes to a third party, it's got to have a triggering event, da-da-da-da. But these carriers are getting where they can turn the cameras on at will. And if the driver's on their 10-hour break, they feel like it shouldn't come on. You see?
Okay, all right.
But if you're behind the curtain in your sleeper berth, what's the problem?
Well, okay, well, first
You
of
know?
all, if people don't, I don't care sometimes, you know, if I give I try to give straight answers on the law,
Mhm.
both on my Facebook page and wherever I go, all right? And whether people like how I see the law or like the law is not, that, you know, if they say, well, it shouldn't be that way, yeah, well, maybe you're right, okay? Let me clear up one thing. One, sleeper berth is not considered a home.
No.
All right? Courts have been unanimous on that. So when it comes to search and seizure law and things like that, tough bounce. You don't get it. Should it be that considered that way? Yeah. I disagree with the Supreme Court, but I'm not them. I mean, they haven't gone to the level of sleeper berths. They talk about motorhomes or not on the road, okay? So I think that probably that same analogy would also apply to, you know, commercial vehicles. You know, and so should they do something? Sure. Yeah, they should. But I mean, to a certain extent, drivers got to quit working for crappy companies. I mean, we have lots of things to bitch about, lots of things I don't like about. And I get calls from potential clients, probably 5 or 6 every day. And I talk to everyone just about for at least 6, 7 minutes, you know, Bluetooth walking around in the car. And for, you know, and maybe every 10 drivers who call me, there's one case. Maybe not even that good. And I'll talk to them. And, you know, it's just amazing. Usually it's a bitch about a workplace thing, or I signed a lease purchase, and I haven't made a paycheck in, you know, 15 weeks, and I've been whole. You know, I mean, the courts aren't there to protect us from our bad business decisions, and they're not there to play HR department. So when it comes to sleeper berths, you know, you know, and by the way, the advice we're given is general. There could be individual laws or circumstances that I don't know about here. So, you know, if there's a specific issue, call me. I'll probably want more details.
So I've got a male-female training team. Either one can be first seat. With a rear-facing camera, now you have documentation. If both people go behind the curtain and close the curtain, it's consensual. But other than that, you have it on camera. She's in the sleeper, changing
What is the
clothes,
question?
swap out.
What is it?
Isn't that one way of looking at it?
insurance when we're.
So in other words, they
These
could
are-
be beneficial in that type of a situation. Now, while we're there.
Hold on, there might be
drive-
other people have questions.
Okay.
I want to just make two quick points about that. First, there are many different employment settings which are what sort of regulated environments where cameras do exist. I had a misclassification case of a woman who worked for Armored Truck Company, and she was counting the cash and stuffing the bags and all that. There's cameras in that company where the cash is coming in. They fill the ATMs all over. You better believe there's cameras everywhere because they want to make sure that the employees are not putting a packet of cash in their pocket when they're filling the bags. And there are many other kinds of companies in which, for security reasons, there's cameras everywhere. Here's the key: reasonable expectation of privacy. The standard is, when someone wants to bring a claim for invasion of privacy, does that person have a reasonable expectation of privacy? There was a famous case out of Chicago. I think it was Marshall's, the store, the department store, right? Marshall Field, there it is. Where a woman was changing in a changing room in Marshall Fields, and there was some employee who had drilled a hole in the wall and was peeping like a peeping Tom through the wall. She sued, and what were the damages? Emotional distress, but there was a big award. Why? Because she had a reasonable expectation of privacy in a changing room. When you agree, as Paul said, to employment with a company, and the company informs you, if they don't tell you there's the camera, they don't say the camera's there, I think that changes it. But if they tell you the camera's there, and now you don't have a reasonable expectation of privacy, then I think it's perfectly legal. Another quick example is on Wall Street, in many corporate companies, they monitor the internet. They want to make sure their employees are not looking at pornography or doing insider trading or other illegal practices, business practices. They check what they're doing, and there's a lot of case law and literature on whether or not companies can do that. One of the key factors, you have to inform the employees, and then, as Paul said, it's your choice. If the employee says, "I don't like this kind of surveillance," you're free not to work there. If they don't object, then employers is within its rights to do it. And you're right, that would help with evidence. Absolutely.
Would the drivers be reasonable in having some type of regulation in place when the cameras can and can't be used? Like their 10-hour break, it's all hiding with the ELD. On my 10-hour break, camera shuts off.
All that could be subject.
I mean, that's something drivers would have to pursue.
Yeah, they could
right?
have subject to negotiation.
Okay.
Okay, so we have some volunteer questions. First of all, we have some people that are here that I didn't introduce myself. Do you guys have a question does anybody have a question that they want to ask before we ask some of the volunteers?
I wanted to follow up on that trainer-trainee type.
I'll talk to you afterwards about that, or it's a trainer-trainee issue?
Well, as
Hold
an
on,
instrument
why don't
of
we
the-
let Desiree ask some of these questions?
Yeah, because we got some
Get 'em going here.
people.
We have some others.
a lot of them.
Oh, I had a different, kind of with the camera, had one on that. We had one truck with a camera, and the guy would pull it up and bring the drivers in and go, oh, look what this driver's doing. That's where that turns weird, right?
Yeah, we don't have all the answers right off the tip of our tongue, even though all three of us here are employment lawyers. Is it weird? Yeah, is there a cause of action? Maybe. That's not something I've had come up, and
Okay.
I had to research,
Well,
so I don't know.
It actually helped because it got passed through the thing, and we're all like, oh, no, you're not putting those in. Once we found out, he was just pulling up going, look, and we
But you consented to having the camera on you in the first place. I mean,
Yeah, we don't.
it's workplace.
Yeah.
I don't know. Depends for what purpose, I suppose.
He was just having fun. Okay.
Okay, I'm gonna read this one from Wayne, and all of you can answer if you have input on it. He wrote, cash advance loan fees for money paid, issues and questions. Is it legal to charge fees to get your money? So a lot of drivers have their money advanced to them on their little card and check, and then they have to pay the fees on top of it. So.
Not when it's paid. If it's being paid as an advance and not when due, and there's disclosure, probably, but this is not, there's some stuff that is federally regulated, and we do federal employment cases, certain types all over the country. We give a straight, I don't think there's a federal regulation, so When it comes to talking about state law, I'm happy to talk about Minnesota employment law. But I would suspect that certainly in Minnesota, if there's disclosure of the fees and it's in advance and not, you know, if they're just, if you're paying to get your paycheck, no, it would not be permissible in Minnesota.
It's in advance. I talked to this man.
Hold on,
already.
we're doing a Q&A here, okay? And I'm happy to talk to you for an hour afterwards. And these are lawyers being asked
Well,
opinions.
I just wanted to elaborate. The question was specifically, they're charging me $4. Well, we all know that
They can charge you
electronic.
for an advance if you've gotten disclosure on it. How's
It's like
that?
an ATM fee.
Can
If
the
you
carrier,
got
it's
disclosure.
legal for the carrier to make money off of this, in other words, because that's the way I understand
As
it.
long as it's disclosed to you.
It's,
And it's in advance.
It's
It's not
advanced,
disclosed,
it's-
but okay.
Yeah, I mean, if it's just a fee, I mean, I thought.
Well, it is.
There could be some interest, you know, if the interest rate, if there's a, you know, a very high rate. I mean, I had a case where employees would borrow $1,000, so advance pay, but pay back $1,250 within 10 weeks.
okay.
So
Usury.
that's, you know, that's usually, right?
Usury.
Right, that's, you know, that's 125% interest a year.
Uh-huh.
Right? Oh, you know, so if you play, if you can do the calculation. But if it's just a minor fee, I don't see a problem.
Okay, all right. Drug testing refusal from James. Driver gave one sample and the administrator told him that he needed more, but he couldn't go again. He walked out of the room to check on his truck and was fired for refusal.
He's screwed. Based on the limited information I have.
The car was being
And
towed.
Hold on, I'm answering the question, sir, please. These are lawyers here to ask questions from truck drivers, okay? Not to get truck drivers' opinions. And I'm happy to listen to your
No.
opinions all you want
The
afterwards.
driver left the screening room because his car was being towed. He left a sample in the cup, but it wasn't adequate.
Would you like me to answer the question, or should we have the gentleman here answer?
I'm rephrasing. Thank you. We'll talk to y'all later.
All right.
Okay. The requirement to give a certain number, certain level, and I can't remember exactly. You got to pee in a cup, and it's got to reach a certain level. And if you don't reach that certain level on the beaker, they dump it out. Okay? And you have to, the company, the test collection site has to give you, I believe, up to 40 ounces of clear liquid over a 2-hour period, and you need to stay until you can pee. So if you just say, I didn't give enough, now I can't pee, and you leave, and you haven't stayed, you haven't not followed the DOT's drug and alcohol testing regs. But the collection site also has to tell you, hey, you know, you need to stay here, we're going to give you 40 ounces of clear liquid. There is an exception to that being categorized as a refusal, and that would be if you have what's known as a shy bladder. So when you have a refusal for being unable to pee, it has to go, the test collection site has to notify the company's what's called a DER, Designated Employer Representative, who has to notify the MRO, the so-called Independent Medical Review Officer, who has to confirm the refusal. The medical review officer does not confirm the refusal, they cannot stand the driver down. But by just simply not being able to pee enough and I can't pee anymore, I'm leaving, that's considered a test refusal.
I just love the phrase shy bladder. That's
You know, I actually had this happen recently. I've never seen the lid on a commode that was round. So when I got done, I set the sample on the top of the commode.
no.
And it slid off.
Oh,
4 hours later, they finally get the sample. Great people, had fun with the nurses and everything. Great time. But I've never seen it happen. But I saw a slide, yeah, too late.
I think they get called for a
But,
test.
yeah, that could have been a refusal. I could not leave, or it would have been a refusal.
I've had people call me and I think I'm getting called for a test or whatever. I don't know how they know, but I usually tell people to, you know, if you get called, I mean, first of all, go immediately. That doesn't mean wait for traffic to die down. You know, or it's snowing out, I'll go later. Or the company told me I could go later. No, you get a CDL. It says when you're called on a random, you go immediately. I mean, even if you're fishing, you're on home time, you have to go for the random drug test. I mean, when you're on your home time, I wouldn't answer the phone from the company, frankly. That resolves that issue. But when you get called, I'd go get a bottle of water and start cussing.
I just want to make one comment here. You know, in terms of the courts, to the question, these drug tests are done for public safety reasons, right? We don't want people who are dangerous on the road, and many other. Whenever courts hear that there's a public safety concern, they are very deferential to companies imposing rules. And so a failure to comply with a company regulation that is designed to serve and enhance public safety is going to be held against the employee.
And these were all litigated years ago. You know, in the late '80s, this came out. I remember I was a member of the Transportation Lawyers Association back then, which was a group of lawyers who represented trucking companies, mostly, and railroads. And I was a young lawyer then. I spoke up at a conference in San Diego that I was attending, and I was the only one to speak up against the drug and alcohol. One of two lawyers to speak up about the drug and alcohol testing regulations, and I was against it because I thought it would be. I considered it an invasion of privacy, and I thought that it would, it wasn't enough safeguards to protect the drivers, and I still feel that way. And these litigate the DOT's regs, which are we provide orders the employers to have these processes. You know, Mr. Hanson's right. I mean, they were held up by the Supreme Court in a 7-2 decision, and Justices Marshall and Brennan dissented, and they said, just because it's a safety issue, we should not be, taking away Fourth Amendment rights. This is intrusive. How can you get any more intrusive in violation of the Fourth Amendment than, taking blood or urine tests? And, the majority of the court didn't agree, but these things are settled, and there is almost no due process for you when you fail. The MRO is the judge, jury, and executioner. That medical review officer who might be the golfing buddy of the doctor who's the golfing buddy of the trucking company owner, he's judge, jury, and executioner. And those same cases that upheld the intrusiveness of mandatory random, and I'm not talking reasonable cause testing, mandatory, upheld the constitutionality of reasonable, of mandatory random drug testing were all the same cases that were used to uphold the ELD mandate. So the drug testing was the government's nose in the door for allowing the government to be intrusive into truck drivers' lives, and it's continued over 30 years.
I have a question. On that last question about the driver that was totally refused, didn't he say he went to check his truck and thought something was wrong? Does that relieve you from being, walking out and not wanting to do the drug refusing?
You can't leave the site. Cannot leave.
There's no reason to leave the site, even if your vehicle's being towed, it has to be towed, that's your fault, not theirs.
You cannot leave the site.
Okay, so that's not.
You're essentially locked up until you leave.
Paul, on the due process thing, I'm with you there. I'm out here I'm third generation. I can remember an old truck stop right out here, right off of 30. You couldn't walk through that parking lot or many, many others without people coming with a handful of drugs. Hey man, you want something? You'd see teenagers coming in at night because they knew the truck stops is where they had to go. I knew companies were dispatchers putting out pills to drivers instead of people. So it was pervasive and it was annoying too. And they'd knock on your doors, hey man, you want any drugs? And this and other prostitution stuff too. It was a nightmare, truck stops. And it was all around us. I was surprised, even friends of mine, who I thought were pretty clean on occasions. Because I just don't believe in drugs, basically. But it sure is nice not to have it all around the way it was at one time.
Because of the drug
And
testing.
the due process confuses me too. I wish we didn't have to give up the due process rights. But somehow or other, maybe it was worth it to not see and experience what was all around us. It's one of those outcome things, but I remember how bad it really was.
I was with one company. I suffered a TIA, mini stroke, in Louisville, at a receiver, and this is from Mr. Gary. I was admitted to the hospital and I was there for a week. The company fired me for this and they black dotted my DAX saying that I abandoned the load and the vehicle in an unauthorized location. The company that maintains the DAC reports is called HireRight. Trucking companies pay HireRight to use them for DAC reports. I contacted HireRight for a rebuttal, but they took the company's side in the dispute. My rebuttal is, how could I move the truck if I am in the hospital? The company said that I did the abandonment deliberately, then docked my final pay for locksmith and truck retrieval. And I was saying, and is saying I still owe them $4,500. The company I am now with overlooked and had me bring in the hospital ambulance to report and hired me. I'm sorry. The question is, can companies and HireRight do that to keep drivers from employment in that kind of situation?
I can handle this one. The answer to that is no. You have a right as a driver to refuse to operate a commercial vehicle if you are too ill or fatigued that to operate the vehicle would be unsafe. And so I think in this case, having a stroke falls pretty clearly in being too ill to drive a truck. Now, unfortunately, we see this pretty frequently that if the driver has a medical emergency, has to leave the truck, the company will mark that as an abandonment, which is basically a death sentence for a trucking career. If you have it on your DAC report that you've abandoned a truck, no one's going to hire you. Now, the remedy in this case would be, it sounds like this driver has already tried to resolve it with HireRight. Under there are consumer protection laws that govern this type of a report. The Fair Credit Reporting Act applies to employment reports of the type that HireRight publishes. And so you have the right to dispute it, but unfortunately, too often the company will, HireRight will simply call up the trucking company says, nope, they abandoned the truck, and then HireRight will close their book on it.
But you have a right of action, a right to sue to ensure, I mean, the Fair Credit Reporting Act requires that the person making the report, in this case would be a report to HireRight, and HireRight have a duty to ensure maximum accuracy. Now, the courts have held HireRight to a really low standard. OIDA, God bless them, took a great class action, or took class action, I can't remember who it was against, but it dealt with it was against HireRight, or USIS before HireRight bought them. And it said that their coding system was inaccurate, how they categorize things, and it was a class action. OIDA did not win the case. So this case, as Pete says, the driver's got two hospital claims, violation of the Fair Credit Reporting Act, or the STA's whistleblower provision, which prohibits retaliation for refusing to drive. Sounds like it'd be a good case if it's timely.
Yeah, on the one hand, there's the wrongful firing against the company for terminating a driver who can't legally operate because of the stroke or whatever illness. And this applies in situations, and the stroke is obviously an extreme example, but if you have the flu, and if you have bronchitis or any ailment that makes you
bad night's sleep.
Yeah, bad night's sleep that makes you medically unfit to drive. You just don't feel safe driving because of your medical condition. You have the right to refuse. And if the company retaliates against you, then you have a cause of action under the Surface Transportation Assistance Act.
I think the ruling actually reads if you're ill, fatigued, or likely to be ill or
So likely, it's so likely to make it.
Do you guys have a follow-up?
It's not a follow-up to that, it's a totally different subject, so if you want to continue with that, that's fine. But it's a totally different question.
Well, okay, do you have a comment on that at all?
No, I agree.
Okay.
My only thought is, it sounds to me, first of all, totally illogical to require a sick employee to continue to drive. It's against all common sense and safety, and also that does the Family Medical Leave Act apply to trucking companies?
Yes.
So if someone,
It's a serious health condition.
right, if they have a serious condition.
Well, the problem is, FMLA is, and I'm glad you segued into that. FMLA provides, Family Medical Leave Act provides a rolling 12 weeks of off-duty, or time off for a serious health condition for you or family. To care for a sick mother and things like that. But you gotta be there, you have to have work a certain number of weeks, and I can't remember exactly, or full-time employee for 12 months. You have to work a certain number of hours. Problem is, there's this turnover in trucking. I don't know that everybody ends up qualifying it because the turnover is so great. I mean, what's a turnover in this country? People last at a job in trucking about 8 months typically. That's a good point, thank you.
Okay, my question is, my husband went to work for, he was actually a previous employee. They were truck drivers together. The guy went off and bought several trucks and John drove for him. And they were struggling to pay us. Paydays got later and later. And John gave him notice. He said, you know what, you don't even need to give me notice. Because the other 2 trucks are broken down and he needed to drive that one to make a living. And it was a month ago and they keep putting us off. They still haven't given us that last paycheck. First it was Fry Miller's the company that they called for, but it was their problem. They couldn't figure it out, and she has given me text messages with random, I'm school shopping with my kids, I can't get it done, and now she's blocked my number. But just, should I file the labor board? I don't want to hire an attorney. It's like $421, but we need it. And
Yeah.
I mean, should we just move forward and say, you know what, pay it forward? Because I just wonder if we would have recourse. I know you can download the form on the internet for the labor board, but I mean, they're obviously a struggling company. Do we even want to waste our time
So they-
doing so he's successful now, he's actually working for a better company?
They're probably counting on the fact that the amount is so small, it's not worth your time and trouble. I would say that there is some merit to that, because you don't want to spend so much time and aggravation on this because of the amount involved. But there's a principle. I think the Labor Department is a smart way. It'll take time. It will take time. If you have text messages, if you have anything in writing that shows that they've essentially admitted that they owe the money, they're making excuses.
We got a paycheck stub.
Okay, well, then what I would do is I would try the low cost, low hassle way, which I think hand it over to the Labor Department, let them take it from there. It may take time, it may take more than a year, but it's off your plate. Hopefully you'll get a result, but just on a practical basis, I wouldn't spend more time and money on it. But there are governmental agencies that will hopefully do the work for you. And also, my experience is companies will often be much more afraid of the government coming after them than a single individual.
So the labor board is where I should go. Now, I don't want to jeopardize their business. I know they're struggling to make it work.
When I hear labor board, because I do some labor work with the National Labor Relations Board, and there's no way you would want to go there. I mean, this is not dealing with a unionization effort, so people misunderstand when they talk about labor work. Mr. Anderson's probably, I speak for him, probably talking about the State Department of Labor.
Yes.
But they don't, some states, the State Department of Labor doesn't necessarily have jurisdiction over that claim. So, your recourse is to go to the court. You might every state that I'm aware of has a small claims court. In Minnesota, our small claims court limit means you go in there up to $15,000 as a small claims.
In Oklahoma, it's
Yeah, well, I mean, go bring it, get it on there. People might need it. It could show up on their credit report, and someday you might get the money. Just as to the size of it, if they were financially solvent, not all lawyers would turn down a small claim. In Minnesota, we have a provision where, in most employment laws, this is a nice thing that allows employment lawyers to practice. So we have a fee shifting statute, which means if we win, in almost every employment law of all federal employment laws and most of them anyway, we get our attorney's fees, our reasonable hourly attorney's fees. We had a case, sometimes it's wrong for a trucking company to piss me off, okay? I'll just relate something very quick. We had a client who got beat out of, he had like a, $1,100 wage claim in Minnesota. It was against a trucking company called Quick Cargo. Quick Cargo for the cameras, okay? He went in small claims court, or we call it conciliation court. He won, and the company appealed and requested a jury trial, which you can mean, small claims courts, you don't get a jury, so they get what's called a trial de novo. If you lose, you can appeal. So this guy appealed this $1,100, it was about $1,100 wage claim. And after he appealed, he hired a big downtown Minneapolis law firm called Meserly & Kramer. And they counterclaimed my guy for out-of-route miles and all sorts of stuff, damage to the truck. So what was $1,100 wage claim, they counterclaimed that. We did a 3-day jury trial on $1,100 wage claim, and they filed post-trial motions. Our attorney's fees were awarded after a trial of $51,000. And we earned every penny of it. I know some drivers, oh, the driver got $1,100 and the attorney's got $51,000. Well, that's what our fees were. After that, they appealed the case to the Minnesota Court of Appeals, and they lost again. Our attorney's fees were $30,000. So now we're up to $80-some thousand. They have now filed a petition for review with the Minnesota Supreme Court. So, I mean, I never thought that this $1,100 wage claim that I got my nose into would amount to that. But these people, I mean, they're financially solid. They're going to be paying us $80,000+. And my client got a penalty. Minnesota has a penalty for late payment of wages. I can't remember what it was exactly. My client's going to get about $2,200, and we're going to get. I have another lawyer we joint ventured it with, a younger lawyer. I spun it to him. He's in another firm. And I came back from Arizona where I spend my winters. And they're going to end up paying us $80-some thousand plus my client. I don't know, $2,500 through it, she can get $3,000, something like that with the penalties. And they're going to pay. I'm sure this big firm in Minneapolis knows how to bill healthily. I mean, he's going to have a couple $100,000 into this case before it's over. And sometimes what carriers will do to screw a driver out of a nickel is unbelievable. But you know, it sort of pissed me off when they beat this poor kid out of his money. So I kind of went on a crusade. But I mean, I know that's a long answer to your question. You know, it probably, if they're not solvent, it's the kind of thing I would normally tell somebody, just move on. Right, toss it up, a bad decision.
They've got like a tile business that has moved from one building to another to like a storage area. And I'm just thinking, oh, you guys are struggling. And do I really want to ethically? I mean, I'm nothing against lawyers, but the society has become so litigatory that it seems like you do. You pay a lawyer $50,000 for work that they do. I know they make $300 an hour and they go to school and they deserve it. But at the same time, my time is more valuable than $300 an hour, and I'm a grandmother, in my opinion. So do I want to waste that time and breath and one more text message or phone call for $421?
We don't get our money if we don't win, though. It may be $300 an hour. You're a little shy on my bill. He's under $300 an hour. I'm well high on that.
Well, that's an average.
It probably is right.
Okay, Cheryl.
I just want to make one quick point.
Yes.
Which is, I know you said they're struggling and all that, and that's fine, and I admire your sympathy, and I admire your consideration of their personal or their financial situation. I know in New York, and I think in most wage and hour statutes, the law provides for personal liability, meaning it's not just the company that's on the hook, it's the owner, because the law knows that very often companies fold, go away, and the money is with the person, the owner. And if the owner is not paying wages, the law permits employees to, that owner is personally liable. I know you don't want to go there, but just for everyone, if you're not paid your wages, it's not just the company who's on the hook, it's the owners. An owner or employer is defined very broadly to include managers, not just the owner, but people who direct and control what you do all day.
So you would say, instead of labor board, they may not even have jurisdiction, something, it's research I would need to do in Oklahoma, it would be small claims court, which
Well,
I actually can do.
Small claims court, but when I say labor court, I meant the State Department of Labor,
Oh, the
DOL.
State Department.
Yeah, I mean, your state or the Department of Labor, yes.
Not the National Labor Relations
Right. That's you.
Well, I know it's a form, I actually looked it up, that
Do
you
it,
just
do it.
download and fill out, but,
I know you feel sorry for them,
yeah. I
but
guess
you're not
it's-
responsible for their bad decisions.
That's right, that's what I do.
You know, and there's a middle ground, which is you can fill out the form, right? And you can either file it or not file it, but you can send it to them and say, look, I don't want to go here, but we need the money. And if you're going to ignore me, you're forcing me to do this. And maybe that would get a response.
Yeah.
You good.
That's a good idea.
That's a good idea.
Just send the form, you know, and up to you, either file it and send it, or don't file it and say, it's done, we're gonna file. You can say, I spoke to a lawyer, you can say, I spoke to 3 lawyers. I've consulted with counsel. I've consulted with counsel. You can have my card. I've consulted with counsel, and pursuant to that, those discussions, I've prepared this form. We know each other a while, I'd rather not go here, but if you don't send me a check, you're gonna force me to do this.
Right, that's a good idea, thank you.
You're welcome.
That was my last ditch effort.
Ms. Candace? Cheryl, you wanna?
Yeah, a lady, Wendy, has a question on automatic manual transmissions, set on automatic mode. And the carrier has disabled the manual mode on the shifter. In inclement weather, makes her feel unsafe. Can she refuse to work due to feeling unsafe? So,
I
the way, what I've gathered is she, automatic transmission, I'm thinking of the truck that I drove, automatic transmission has a switch up, and they have disabled where you can manually shift the gears. So the company has disabled that mode. And now she's only got whatever transmission decides to do. So when that transmission, she's on mountain or weather.
We're in control of the vehicle anymore.
She don't feel safe in control of the vehicle because she can't manually shift the gears when she thinks is safe in weather conditions. So if
Is it
she
unsafe?
refused to work, feeling unsafe in that manner.
Okay, let me go. This area that the question comes from will probably require a lot of questions from the driver, okay? But it's 80 to 90% of what we do, okay? So the Surface Transportation Assistance Act protects you from retaliation for making complaints related to violations of commercial vehicle safety regulations. It's telling the government or telling a supervisor. Okay? 2, it protects refusals to drive where driving would actually violate a commercial vehicle safety regulation. Like refusing to drive because one marker light of the clustered 3 is out. Okay?
Right.
Or refusing to drive because you got a crack in the windshield, the prohibited crack. Or refusing to drive with one bad tire even though it's not an out-of-service tire. Okay? Any minor violation, any violation, major or minor, the law protects your refusal to drive. Small oil leak. Because the rules prohibit, there's a DOT regulation that says you can't have any oil leak. I don't know how many trucks are out there that would qualify for being in complete compliance. Now, there's a second category of protected work refusals. Here we got protected because it would result in a violation. 2 is refusal to drive based upon a reasonable apprehension of serious injury due to the vehicle's unsafe condition. Now, I don't know if that having this transmission disabled, maybe there's a bad weather refusal could result in an actual violation which says you cannot drive, the regulation 392.14 which says you cannot drive where driving, it says something about use caution when conditions of snow hazard, whatever, rain, sleet, smoke develop, and when conditions become sufficiently dangerous, you shall terminate operations. You guys probably know the regulation. I don't know that this would violate that. But there's this other category of refusal which says refusal to drive based on a reasonable apprehension of serious injury. And the statute defines reasonable being objectively reasonable. And the courts of the Department of Labor, these go through the Department of Labor, have interpreted that to mean, would an objectively reasonable driver, same type of training, experience, etc., believe that driving in snow where you can't use a manual transmission, you gotta go by automatic, is unsafe? I've been around trucking my entire life. I'm 60 years old. Never been a truck driver, so I don't know if it's unsafe to take an automatic in. I know there's automatic trucks. It doesn't strike me as being unsafe. So the rules don't protect you from feeling unsafe, It's just like when drivers, I try to get direct right. So was it unsafe or did you just feel unsafe? I mean, there's differences in what words people use. Like my company, I told him I felt uncomfortable. Did you refuse to drive? I told him I felt uncomfortable driving the truck. Well, what? The seats didn't feel good? You know, I can be a bit of a smartass, but I'm trying to get to the point. Feeling unsafe does not make it unsafe. Does not make it objectively reasonable that you felt you were unsafe. So I would need more information for this. It's got potential. Doesn't sound like a bad case if it came up. But I don't know. You guys are drivers. I'm
Well,
not. Does
I
driving
drive
an
an
automatic in
automatic.
snow
The
feel?
And I
way-
think
yeah,
with the
okay.
manufacturer, with that, I don't know that you could disable the.
It seems.
One company I work for,
I don't know.
Okay, but there's
Say-
automatics
Why
out
would
there now,
they
right?
disable the manual? Because, I mean, I drove an automatic too, and there are certain situations,
When you
and
need-
he drives the automatic, there are certain situations to where you do need to shift and use the manual. So, I mean, I know that's not a lawyer
In
question.
downhill situations, in
Huh?
steep hill situations, you want on automatic, you want to be able to put your transmission in manual to engage your J
Correct.
brakes.
Well, okay, but hold on, I don't. Automatic transmissions are relatively recent to trucking, okay? They got them because people can't learn how to shift, I guess. But there are trucks that are completely automatic, okay? So my understanding as a lawyer who represents truck drivers is, when you're going down a steep grade, an 8% grade, you're gonna use the Jake as much as you can, and you're gonna use what they call retardation horsepower in lower gears to slow the vehicle, right? When you have an automatic, how do you slow the vehicle going down
Put
the
it
grade?
over into manual and choose
You-
the gear you
that's-
want to go down
So,
the hill in.
okay, but what about,
Top
aren't there trucks that are strictly
I had
automatic?
one, my Jake brake worked in mine. It still wasn't, I didn't feel it was adequate enough, because you still had to ride the brake too much. But our
Oh,
Jake brake
right.
worked,
That's interesting.
but it was weird.
Most
That's
of
all
them
I can say.
have a manual.
See, ours,
Have a manual
they,
function.
just like with that
Okay,
lady,
so
they
manual
overrode
function.
it.
When you get ready to go down the hill, say.
So you can drop a gear.
You,
Yes.
You can
well,
drop
you
a gear.
put it in,
Yes.
you
can
put it in
freeze
that gear
that
and it
gear.
will only go up to that gear.
Correct.
And then your jakes will kick
With
in.
your jake.
Whether you wanna go down to 6th or
But if
8th.
it's disabled,
Mine
then
was
you always
disabled.
got
Hey,
that
disabled, you
engine doing
can't drop a
what-
gear?
No.
No,
No.
no.
What gear do you run in?
Whatever gear
Well,
the
whatever,
transmission
if
decides
it's
to run.
35 miles an
it's
hour, you're
supposed to.
supposed to be in one gear lower than that, depending on the grade of the mountain. And with your Jake brake, and you keep it at that speed, and that's the gear keeps it at that kind of speed, so you don't burn your brakes up on your trailer.
Well, I guess I would say that maybe refusing to drive through mountain grades would be a refusal. So based on what you're telling me, I'm not so sure about weather. I don't know. I wouldn't know.
Ours was set up when the manual was turned off. We got it downshifted, not enough, but it actually did go through the weight and the steep. It was like a computerized thing. So mine did downshift. I didn't personally, because I liked it a little bit lower. But ours did go through the downshifting. It went by steep grade and the weight of the vehicle.
Computerized vehicle.
Computerized.
Yeah,
Hey, I've got guys.
Is yours like that?
mine wouldn't do that.
My thing was, I guess the transmission.
Could you speak up a
wasn't-
little, please?
My transmission, I guess, was not adjusted enough. So in the snow in Chicago, when I'm coming to a stop, it downshifts itself. So therefore, I'm losing traction and I'm beginning to jackknife. Now, I don't know how you fix that. They try to adjust it. I don't know if it's an adjustment or not. I don't know if yours does that. But mine has done that in the rain, coming around a curve, not too fast, where I'm supposed to be. And I've almost lost my truck because it's downshifting. Now I don't know, anybody else's transmission is set up that way, if it works that way. I've talked to drivers on the road, they'll say, well, no, mine isn't that way. Well, mine is. So I don't know if there's a different transmission or what. And I've also, my company, they told me that we're going to set up a point to where we can hit the brakes for you.
No.
They've got them already.
And
Yeah.
so I
Why
asked
not
them, I
get
said,
that on
so
card?
what would give you the signal to hit the brakes? Well, if your distance, you guys have that it tells how far you are. You got these beepers that go off. You're too close to the coast. Well, that went off when I ran around a curve with the construction barrels up. So it saw that as a person. So it goes off beep, 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 beep. So you hit the brakes there for me? You know, and I don't know how that works.
Mine sees an overpass and hits the brakes. I'll be going down the road not expecting it. It'll go beep, beep, boom. And I'm like, holy crap.
It is-
And I got
How
that
does
tanker
that
stuff and
say?
it slams
On
in.
guard or Bendix system.
Yeah, well, we're gonna see more of that.
Thing scares me to
I've had drivers who have asked me that kind of question, can I refuse to drive? I do not believe them taking the human element out of it and letting the truck brake itself is safe.
Well,
It's rough on ice when it does
It's a fine line, and
Yeah.
I'm not sure a judge would buy the argument that it's unsafe to have these safety devices operating, so to speak, where the truck brakes for
Well, how
you
about-
based on robotics. But hey, we're going to have robotic trucks in 15 years, so.
better. So I guess that eliminated that question, because I was like, yeah, it might not be about the feeling part of it, but how can a company take and disable certain things in a truck that we have to have? I mean, how can they disable
I don't,
part
I
of the
mean, how
transmission?
physically can they do it? I have no clue.
No,
Not physically,
I would say
I mean-
if the truck was sold to operate in a certain way, and they're taking certain parts of it
Parts of away
and
from
rendering
you.
them useless, and they're, I don't know, I mean.
Wouldn't that be the same as governing a truck? We can go 180 miles an
Yeah,
hour, but
that's-
Well,
they
yeah.
govern us.
Okay, there's a regulation, there's a lot of catch-all ones, and I think it's 396.83 or something. And it says all parts that may affect the safety of operation shall be in good working order at all times. And not only those parts which are mandated by the regulations, but any other parts that may affect safety. So I think maybe it would fall in under that clause. I have a question too for Mr. Aronson, if we get a spot, because he's the kind of a guru more than I am on Title VII. So.
Okay, why don't you ask? Yeah.
Okay, there was this issue of who's a supervisor, because there's a heightened liability when the harasser is a supervisor. And we had that in our case with the trainer raping the trainee in parking lot at Lowe's in the 10th Circuit, okay? Country. And in the CRST case where EEOC got sanctioned at the 8th Circuit, they held the Court of Appeals, well, I think the district court held it too, the Court of Appeals affirmed it, held that a driver trainer is not a supervisor, as I recall. That was one of the issues. And we were arguing in the other case where the trainer raped, which was in the 10th Circuit, and it looked like the 10th Circuit law was more favorably disposed towards finding anybody who could influence a hiring decision was in fact a supervisor. So could you sort of tell us where the state of the law is as you think it's going on who's a supervisor and who's not, who would be subject to that heightened, or that at least easier to prove sexual harassment in the case of a supervisor as opposed to a coworker?
So generally speaking, and it's an interesting question, but generally speaking, not limited to the trucking industry, titles are less important than control and then power. If someone, this phrase, if you control the manner and means of production, which really is a fancy way of saying, if you're telling the employee what to do every day, and if you have the power to hire and fire, to change hours, to instruct, to require certain performance, change a schedule, to reassign, all of those are indications of control and of some sort of superior status. And so courts have said over and over that the particular title is less important. It's really what you're doing. Now, companies try to protect themselves. Sometimes they put in language, I can imagine, with a trainer-trainee, where they say that it's not a supervisor. I would think, though, and as you see, there's the difference in the circuit of the 10th and 8th Circuit. This is highly fact-specific. It also has to, I I would say what has been published by the company, whether it's in an employee manual or given to the employee in some other written form about what the hierarchy is. If there's a reporting chain of command that the trainee or employee knows that if there's a problem, go to someone else and not the trainer or not the particular driver, that might factor into the balance. But I do think that more and more courts are piercing the titles, they're piercing the formal structures, and they're saying who is controlling this employee, who has power, hire and fire is used, and it's, as you said, it's not just hire and fire, it's to recommend hiring decisions, it's to participate in it, and this gets down to a very real, practical, factual question. When this trainee is going to be evaluated, it seems to me, the person who has the greatest impact on that trainee's future is the trainer. What the trainer says.
They fail him. She doesn't pass training.
Exactly. So really, it's not just. I mean, if and I would argue, if I'm the trainee's lawyer, I would argue that the company has invested in this trainer the power and duty to evaluate this trainee, and therefore the company has delegated to this trainer the responsibility for determining the trainee's future. Now, that responsibility, what can be more control, what can be more power than that? If that trainer holds, in his hand the button, the green light or red light for this employee, that's the decision to fire.
So you would think maybe the circuit's decision in CRC is probably an aberration, but then the driver trainer is supervised.
I think so, and from what I know, there
were a lot of screw-ups in that case besides that.
Right, exactly. I think that I'd have to look at the opinion again, but that was a case where unfortunately the EEOC sort of
screwed up,
mishandled. Right, yeah, and I think there was a context of poor lawyering and of bad decisions made on the part of the workers' lawyers that, on balance, probably tipped things in favor of the employer and against the employee in that. But I think that, I feel in so many of my harassment cases and so many of my employment cases that if there's strong evidence of control and by an individual, even if the title is not a supervisory title, we've got a good shot. And on a practical basis, if it's going to be an issue of fact, and there's not going to be summary judgment, is the company going to want to gamble that? And I think those jurors see through the titles quickly and would be sympathetic to an employee to say, this is the person who controlled my day-to-day operations and also could make an important decision about my future.
I want to add to this. Christina's going to have a question after me. I don't know if it's in the same area, but I want to ask this related to the CRST because there's a number of companies, CRST, Covenant Transport, they do the team business model, which we really discourage new women entering to get involved in. And what it consists of is they bring you through the CDL school, you go on with your trainer, and then you have to do team driving with another student a lot of times for 6 months, which is really dangerous, and the training is horrible, and it's just frightening to know you have two students that know nothing operating this truck 24 hours a day. So maybe they had a good trainer, and they didn't have any problems with their trainer, but now they have a co-driver that is harassing them or is unsafe or terrorizing them or is getting violent and stuff. And so some of these cases, they say, well, that's just another employee. They can't hire you, fire you. They don't have any more clout than you have. You're both equal employees, and we're not responsible for their conduct. I mean, it's like he said, she said thing, but a lot of the stuff happens between these co-drivers where one of them thinks, well, you got on my truck. I got this truck yesterday, therefore I have 1 day more. They
have a lead driver. They assign.
Yeah, they use the term lead driver, which implies to me that, and it implies to these lead drivers, I'm the boss of you. And they're really not the boss of you. It's just you got seated on the truck before the other person. So in that kind of a situation, would you still be able to have this kind of defense to say, because it's, the perception is, they might not be able to hire or fire you, but the perception is you're still the boss of me.
Right, so the key word here is notice and knowledge. I would advise in that situation for the employee who has a problem complaining, immediately notify the company. Once you put the company on notice that this coworker is harassing or doing something that is wrong, the company's responsible. The standard usually is knew or should have known. So should have known gets harder to prove that even though I didn't inform the company directly, this was happened over such a long period of time, it was so open, there were circumstances in which the company should have known about it. Trucking context, I think that's hard to claim because you're out on the road. But just an email, a written complaint, not oral, something that, or if the company has a hotline, make the complaint, so that once the company is informed of the coworker's conduct, the company now knows, and if they don't do anything, they're endorsing it, they're ratifying it, they're adopting it. Beyond that, I will say that again, if the facts show that this lead driver has some power, has some impact on the driver's and the employee's future, I think you have an argument. I will say, from my opinion, without having seen the individual facts of any particular case, I think it's an uphill battle. If it's a pure coworker, to hold the company liable without notice. So my first advice is, if there's bad stuff going on, tell the company, put it in writing. Sadly, that typically is ignored. But once you're on record and you notify the company, you've got the company on.
Okay. Because you have the paper trail.
Right, and they know.
Okay.
And they ignore it, they fail. They fail to, once they know and they don't take action, and there's subsequent harassing conduct or
Retaliation for reporting it, which we see a lot.
well, that's something else. Retaliation is a whole other, that's a separate claim. That's a separate claim. If there's retaliation for reporting it, that's a whole other legal claim. And I just want to say one thing. Juries and courts, statistically proven, really respond favorably to claims of retaliation. When an employee complains and then a company punishes them in some way, juries get that. I think it's just common sense that people understand that companies don't like it when employees complain, especially if they raise uncomfortable words like harassment or sexual harassment or discrimination. And if you're punished for that, statistically it's proven juries are more likely to rule in favor of the return of verdict in favor of the employee than almost any other area, whether it's sexual harassment or discrimination based on race or religion. If you have a claim of retaliation and it's a real claim, bona fide, the likelihood of success is strong.
I don't know what category it exactly falls in, but just sitting here listening about the sexual harassment and stuff earlier, it crossed my mind about something that happened about a year and a half ago, and I wanted to ask about, I wanted to give you the situation and then see if there was some kind of discrimination against me from.
So this is a hypothetical, right?
It's an actual scenario that happened,
Okay.
but I didn't know
with you?
Yes.
Well, this is public here, okay, so this is this is a year and a half ago, right?
Yeah,
Well, we're outside the statute of
we're blowing
limitations.
past everything. I just want to know, listen, I'm a friendly person for the most part. I talk to everybody, and if I'm somewhere and there's another driver in there, I'll be like, hey, I'm going to so and so to eat. And, would you want to go with me? Be it male or female, because a lot of times, on the road, drivers is by themselves. I'm one of the people I'm friendly, but I'm not friendly. If you get what I mean, I can't just walk into a group of cows and be like, hey, y'all want to go to dinner? I kind of recluse into my truck if I'm at a truck stop. I run back to my truck and eat. But anyway, to carry on. Let's say I go to dinner with it's got to do with, I guess, I don't know how to say it, racial, like ethnic, you know, the colored person. Let's say I go to dinner with another person that's white, and we go to dinner 2 or 3 times, you know, we're same drivers, and not like the next time I go to dinner with someone that's, let's say, black. And the company comes back, like I get a phone call from the person that I went to dinner with that is black, and they go,
Sorry?
I got a phone call from the company and asked what we did when we went to dinner. Did we, you know, what was the extent of our relationship when we went to dinner? And I'm like, what do you mean? And it was like they grilled him about what we did when we went to dinner and what we did afterwards and where we went and when we came back and all of that. So I went to dinner with another person that was white, and we had dinner. Matter of fact, it was 2 guys that were white. We had dinner at Carrabba's. We came back and nothing was ever said.
The same company?
The same company. And then I go into the terminal a different time. I go with a different, you know, black person, and they get the same question, what do we do? But, you know, when it boils down to it, they didn't ask the white person that I went to dinner with, but because I went to dinner with a black person, they asked them, well, what did y'all do? What's y'all's relationship? And then it's like, but they don't personally come to me and say, hey, what's going on? They go to the guys and ask them.
Did you ever feel like you should have called them and asked them?
I felt like, I was kind of like, what is going on? I mean, like.
But you didn't ask them that.
I'm not a flirty person. I try to be friendly and, you know, talk to people, but it just like, I actually had other drivers that worked for the company call me, also black, and tell me that they had been grilled about, they had seen me talking to them and they wanted to know why I was talking to them. And I felt like, oh my God, it's like, what is wrong with me? Are you trying to say I'm something that I'm not? Are you trying to say, well, I don't want you talking to black people, or you can only talk to white people?
But did you ask them?
I came up to I said something to them, and they were like, well, we don't care, blah, 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 but how is it that I have all these people telling me this, but y'all were saying, you know, nothing?
Right.
And it's kind of like.
So what they say?
They didn't say anything. They just said, you know.
You feel like it's a violation of your privacy to a certain.
Well, I feel like it's almost like, because I'm a female, obviously there's not very many females, and you know, as y'all know, like a lot of females, they kind of like brush another female off, and so, you know, I don't care about going to dinner. I mean, we ride in our separate vehicles together, whatever. It's a dinner between professionals.
Did you feel like they were looking for a reason to make a complaint?
Yes, I did. I felt like, and I was kind of like, I talked to my boyfriend, and you know, obviously, you know, he's like, well, I'm okay with you going to dinner because there's the trust, but it's just like, why are you asking me? Why are you only asking the black guys? Why is it like, you're telling me I'm not allowed to go to dinner with somebody other than a white person?
Did they ask the white males if
No,
they
they
went to
didn't.
dinner with the black?
My hunch is that there's, again, this is seeing the pants, that there's probably would have been no claim there. I mean, it's bad conduct, but there's nothing material. What Supreme Court has used the term materially adverse. There's a case called White versus Burlington Northern Santa Fe, and one standard applies for sexual discrimination or certain discrimination, and one standard applies for harassment. Okay, but generally something has to, in cases of discrimination, there has to be something that adversely affects your pay, terms, or conditions of employment. In a complaint-related case, if somebody's complaining of sexual harassment, racist harassment, whatever they use the term, isn't the type of, is what they're doing to you going to deter future complaints? Was it materially adverse enough to stop you from doing something in the future? But this case, you weren't the victim of the harassment, or what could be perceived as harassment. They're asking you information. probably for an impermissible reason, but I don't think there would have been any sort of claim there. Although it doesn't pass the smell test, that's for sure.
No. Well, they never asked her question, just the black guy. So
Yeah.
therein lies the rub. Why?
So, what do you think?
Well, I think it's foolish. It's very foolish practice that the company is engaged in. That's one. What jumps out is that the African American drivers, they are the ones who potentially, and I say potentially, I agree in many ways with what Paul said, they would have a claim. I mean, the way you frame their claim is that when they are being, in a sense, it's really more of a harassment than discrimination because there's no adverse action. But you could claim, this is again now being a little creative, that the African American drivers, that the company has created a hostile work environment for the company, for the African American drivers, because they are subjecting them to strict scrutiny and to questioning or intrusive practices for the same conduct that white employees are not subjected to that kind of scrutiny or questioning. You could say that there's almost a de facto practice or policy. And again, I feel that, as I'm saying, it's a little bit of a stretch, that they're discouraging black drivers from going to dinner with white drivers, and particularly with white women.
You're playing on stereotypes in the
See, my
process.
issue is too, I don't think had it been a male that they went out with, a white male, nothing would have ever been said. That that's cool. You know, and like
Or a
I
white
said,
female.
Being the female, that was my thing. Being a white female, you know, I'm not prejudicial towards anybody. It's like I just want somebody to sit down and have a nice meal with, have a good conversation, you know, be professional, come back, bam, we're gone, you know? And it just,
It bothered you. But it wasn't directed at you.
But,
It wasn't
you know,
you,
it
yeah.
kind of makes me feel like, are they trying to, you know, direct something towards me to where they can use that against me to say, oh, well, you know, you're doing this, this, and this, so we're going to just, you know, we're going to boot you out the door.
I see that
I
they're
think
doing
it's
it more to
more just-
intimidate them to not go with you
Well,
anymore
see-
and make them feel they're being watched.
There was a comment made, like a guy had said, oh, wow, you know, she's cute, you know, and the lady, a certain individual that worked there was like, you need to stay away from her.
That was my thought, that somebody's got it out for you, or drama queen, you know, like, oh.
But I'm not. You can ask me, well, ask the ladies that know me, I
somebody else.
try to,
This
You know?
is wrong, foolish, offensive. Right now, in terms of your rights, I don't think it's illegal. Remember, to bring a claim under either harassment or discrimination, you have to identify treatment that is targeted at you because you are in a protected class, meaning because of your gender, because of your race, your religion, etc. So, if anyone has that claim, it would be the African American drivers, that they're being subjected to discriminatory treatment, harassing treatment because of their protected class, namely race. And you said, well, maybe it's because you're a female, because had you been a white male or a black male, they wouldn't have done it. But they didn't do it to you.
Right.
There is this concept of
I
third.
get what you're saying.
Yeah, so it's a harder one. If anything, it would be the black drivers who could potentially make a complaint. Potentially.
Sonia, do we have time for, does everybody have?
I'll keep
are
going
you
as long as
okay?
you guys do.
Because I have, I have 4 more on my paper and she has 1.
Okay, this is from Jeff. I work for a small company, about 10 trucks, been here 8 months. Since started, we run a lot of hours, 17 and 18 hours a day, and obviously logs are altered. Well, I'm tired of running like that, and I'm wondering if I tell him I refuse to run illegal anymore, can he fire me? And if so, could I take him to court, and what would he be liable for? Also, do I need a witness? That's why I was fired.
Well, this one, it seems pretty clear cut to me based on what the driver's saying. Again, under the Surface Transportation Assistance Act, you have a right to refuse directive from a supervisor to violate a DOT regulation. So in this case, the driver's being asked to violate hours of service. The damages that would be available to this driver, should he prevail, would be, let me back up. So first, what the driver should do is document that he's being asked to violate hours of service. Second, that driver should refuse to violate the hours, and he should document that refusal. Many companies use, especially larger companies, are using Qualcomm or some other sort of closed system to communicate with dispatchers. If we get a call from a driver prior to that driver being fired, we'll usually advise that driver to send a text message or make a phone call, and if they're in a state where it's permissible, to record that phone call so that they can document, okay, they asked me to do something illegal, I refused it, and then I got fired. Then the first step is for that driver to file a claim with OSHA against that company, and then go through that process. The damages that would be available to this driver, just to sort of finish out the question, first of all, your back wages. So if the driver is unemployed for 2 months, the driver would be entitled to what they would have earned during that period had they not been fired. The driver might be entitled to compensatory damages, which covers your emotional distress, basically your trouble that you experienced from being fired. That's going to be largely circumstantial. Did you get a job 2 days later? Probably not much of a claim for compensatory damages. Were you unemployed for 6 months because they put an abandonment in your DAC report? Did you lose your house? Did you get divorced? Basically, the more severe the consequences of the termination, the stronger the claim for compensatory damages.
Okay, then you can get punitive damages.
Yeah, punitive damages are sometimes awarded by a judge to punish the company in an instance where either the violation is so severe that it's obviously willful on the part of the company and they need to be punished, or if it's a huge company like a UPS or Martin Transport that has repeat violations, that has a history of discriminating against drivers and retaliating against it for this reason. Sometimes the judge is going to say, well, this person was only out of work for a week, but company, you should have known better, so we're going to award, a six-figure punitive damages. We're going to,
we've only hit 6 figures once on punitives.
But it has happened in an instance where a company really needed to be punished because there was a repeat bad actor.
What about the witness part he's asking about? Do I need a witness?
If the driver can document the actual communications with the company, that's going to be the best evidence.
Okay.
The other thing that a witness would be helpful for is sometimes companies are going to try to say, yes, we got the message that he was refusing to violate, but the real reason we fired him is because he mouthed off to the dispatcher.
Right.
In instances like that, the burden is on the complainant, on the driver, to show that they would have been fired, to show that even if the company has articulated another reason that they would fire the contributing factor.
The company has to prove if there's a mixed motive under this law. Driver's burden is simply to show that the protected work refusal, hours of service, or protected complaint on any safety issue contributed to his firing. And we have to do that by a preponderance of the evidence, 51% probability. Okay? If we meet that burden, unlike the Title VII type cases with race, religion, sexual harassment type cases, we don't have as hard a burden as they do. If we just say, hey, could be one of several reasons, just a contributing factor, 2%, then the burden shifts to the employer to show by clear and convincing evidence that they would have fired that truck driver absent his hours of service work refusal, or refusing to drive with a load that was 400 pounds overweight, okay, or whatever it was. So, and that's more like that means that the court has said that proved by clear and convincing evidence means it's highly probable. So we almost always have our foot in the door if we can do anything, even suspicious timing, to link a protected work refusal, like refusal to break hours of service. Hey, Joe, I'm out of hours. I know I only got 20 miles to go, but I'm falling asleep at the wheel. I'm out of hours. Blah, blah. I'm pulling over. And then we get the call come back, or the text in the case of a small company. You SOB, you got to get it there. Or Just get it there and I'll fix your logs later. You know, this day, and Pete highlighted something that's important. Document, 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 okay? And I think maybe those were Mr. Aronson's words, but the best cases we have are the ones where the driver comes to us before he's fired. I'm driving for this outlaw outfit 18 hours straight. We know you can't do that legally. And I'm falsifying, it doesn't say here, but we know he's falsifying his log, which is a felony. Each false log is a felony and it's punishable in jail, prison up to, I believe, 5 years. So if you could spend a long time, a lot of drivers I know can spend a long time in the federal pen. It's a practical matter, there's rarely a prosecution, but having false logs in court is problematic for us. Okay?
Creates a credibility problem.
Yeah.
The company's going to say, even if they were directed by the dispatcher to falsify the log, the company's going to say, look, this driver was loose in observing their hours of service regulations. We've already shown that they can, that they're willing to break the law. Therefore, you should, weigh their testimony, or you should take their testimony with a grain of salt because clearly they'll falsify the logs. Who knows what else they'll falsify? Well, so it can create real problems even when there's a case that is otherwise strong on its merits. If there's false logs, it does not do the driver any favors.
ELDs are going to resolve this issue.
I would think they're just looking at the facts of the case. Two things. One is that advice to Jeff. I mean, it sounds like this practice is not just affecting him. I would have him talk to some other drivers and see whether or not they're all being put in this situation. And if you get a little team together, whether it's 2, 4, 6, or 8, you've got 10 trucks there, and they're all then going to complain. I mean, at a practical level, is the company going to fire everyone and lose its workforce? That's one thing. That's going to put the company in a tough position. Second, questions of credibility and who's right and who's wrong. You got 8 people, 10 people saying, or 5 people saying the same thing. It changes the dynamic significantly. And also, if there's any way of showing, documenting actual hours versus what the logs show, that's something as sorry.
Now
Peter was saying is having, I've had that in many wage and hour cases where, the company has one set of sign-in sheets, but one of the employees or one supervisor who was wanted to do the right thing kept another set. And so when confronted with the actuals versus the doctored records, the courts take notice. So if they can keep records of what their actual time, and also don't go alone. Get other workers to work with you on this.
Yeah, and that's great advice. There are always fuel skips, toll slips, toll tickets, scale tickets, credit card slips where you bought potato chips at the petrol and 2 could carry. I mean, those things are all existing out there to recreate it, which is problematic for us as lawyers. Most of the hours of service cases don't. Well, I should say, a good chunk of what we have don't involve where the driver's already falsified. And I mean, I've been around long enough to know that I think probably getting all 10 together, there's some drivers who simply want to falsify. They want to they're paid by the mile, and the more I run, if it's 4,500 miles a week when I can legally do about 2,200, they're just going to do it and maybe try to match up the fuel slips, show that they got in and out of a Walmart distribution center in 15 minutes, But there is always logs can always be reconstructed. Judges do sort of look in a funky way at drivers who falsify their log books. But, you can build a case before it happens. Okay, start running legal from here on. Let's see what this guy does. Or have you turned in your logs yet? Drivers think they can't change their logs. You can. You can change them to make them accurate. It is illegal to turn in a false log. So I'll ask a driver, well, I haven't turned them in for 2 weeks. I said, well, okay, you got a 34-hour restart coming up, off duty. Get out your slips, where you loaded, where you unloaded, the bills of lading, the fuel slips, and reconstruct your logs to make them accurate. And now turn in. He said, well, that'll show me, I drove 150 hours in 8 consecutive days or whatever it is in violation. I said, better to show the violation than to have a felony on your record. You know, and there you can start afresh and, okay, hey, I'm way over on hours. I can't drive for 4 days, 34 hours, okay? And then you put that on the text message. The other things drivers need to do is download tape a call. You know, drivers, you know, we have a list of the states where you can't legally record. It's right next to our assistant's desk. You know, start using the tape recorder, and when the company calls you, always let it roll the voicemail. This day and age of technology, with this here, to photocopy text or to take a picture of a Qualcomm message or a PeopleNet message or a bill of lading, or I got a little recording app on here. Okay.
Now, our company is against the policy to record any dispatch or anybody without their permission.
Oh, big deal.
It's right up. They make us sign it. They do.
Okay, so what?
Okay.
Do it anyway?
Do it anyway?
Well, it would, you know, if you're trying to document illegal retaliation, yeah, I'd say do it. You know, the other two lawyers may disagree with me, but look, you know, if somebody's asking you to go to bed with them and you'll give you better runs, you know, you tape recorded our harasser, you know, I mean, yeah, I don't know. Because my initial impulse is to say big deal.
Is it against our policy? Yeah, that sounds really good.
Yeah, that's right.
Okay, I'm gonna go.
Well, I didn't hear the other two lawyers, what they think about breaking a policy and recording it, to document illegal or discriminatory.
The internal company policy?
Yeah, it's in our handbook.
They didn't. Well, there's something called what's called the doctrine of after acquired evidence. Okay, there was a case called Nashville Banner versus McKinnon that went to the Supreme Court. It basically says this: if you're fired, let's say you're fired for being black, okay, and after the lawsuit starts, a year later the company finds out you embezzled $1 million. That doesn't mean you still can't maintain your lawsuit. What it means is your damages will be cut off upon the discovery of that embezzlement if they can show they fire employees for embezzlement of $1 million. Okay? So the fact that if you're being harassed and then you document it through recording and you file a sexual harassment case, okay, and you hold back that because you got a lawyer who might say, I don't want to give that to you, so we're not going to give it to him. And you hold back, and later in discovery, of course, you'll have to give it to them if they ask for it. And you give it, and say, oh, she's fired today. Okay, big deal. I mean, well, maybe big deal not. I don't know. But I would err on the side of documentation as opposed to being fearful of violating a company policy, which might provide them a legitimate non-retaliatory reason for doing it. I'm interested to hear what Mr. Henson says, because he does more Title VII work.
So, as I understand the question, you know, you're saying if there's a company policy that says no recording, and then in the course of recording sexual harassment, or that you record sexual harassment, then the company says, oh, you broke the company policy, you're fired, right? So, a couple of things. One way, if the person came to me before they turned over that recording in litigation, I would say, I would use that recording, I would attach it to my complaint, my internal complaint to the company, to say, I am being sexually harassed. Here's what happened. Here's a recording to support my complaint. Now, that complaint, not the recording, the complaint is what's called protected activity. You can't be the victim of retaliation. If the company retaliates against you, which means fires you or takes any adverse decision against you because of response to your complaint, that's illegal. You got a great claim of retaliation. So I would try to say that the recording was part of the complaint, and the recording was protected activity.
Yeah.
Okay. You know, that's the way I would handle it. Now they might still say, well, we have a policy that prohibits recording. I would then argue, well, your policy is contrary to the codified policy that gives workers the right to engage in protected activity. What if they have policy that say no employee can complain about harassment? That's clearly illegal, right? So now I'm saying, but part of my complaint of harassment is the proof, and the proof is the recording. Now, having said that, that's how I handle it. In my experience in harassment cases, I have a general disinclination to or disfavor of recordings. I find generally the quality isn't so good. You can't hear it so well. Always in New York, it's legal to record as long as one person to the conversation knows. Meaning, as long as the party recording knows.
Single party.
Right.
Okay.
So, nevertheless, I find that sometimes it has the flavor of being sneaky.
Mm-hmm.
It has a little bit of like a scheming plaintiff setting up a case.
Yeah.
I had a case against a major retailer, and there was the plaintiff went around and questioned coworkers, and was saying on the recording, when she played it to me, she told me, I have this bombshell recording, and there she is on the recording, really trying to push her coworkers. Well, you remember when he said that, right? And then the coworker's like laughed. She goes, yeah, he like the coworker said he was joking. Right? She goes, but it was really it was really insulting. Bottom line is, it sounded like she was leading, and trying to build her case. So the better ways to do it, I prefer confirming email or something, or maybe a complaint about it. I always worry that plaintiffs don't seem like they're trying to manufacture the case.
Right.
But depends on the circumstances. If you have the recording, and if that's the best evidence, attach it as part of the proof to the complaint. And I think you have a good chance of getting them clothing it as protected activity.
My question is, why would they have a policy against you reporting your dispatchers? And if they had said that to me, that they would not be allowed to call me. If they called me like this, I wouldn't answer the phone. They would have to email me or text me.
Right.
And even though I have a very reputable company, when he calls, I just tell him, text it to me so I can read it, so I can go back and look at it later.
Well,
Constantly.
Back in the day, we recorded everything. And not that we were trying to build a case, but they would lie. Be there at 8 o'clock. You get there at 7 o'clock, and then they say, "Oh, you were late with your load." So we recorded everything. So if a driver records everything, then we can worry about the legalities of it being in this state or not. But he's got a history. I record everything, so they're not trying to frame somebody. Would that be a one train of thought of going about it?
Yeah.
Document everything.
The we have today is, and I'm dealing with, most of them are not sexual harassment cases.
Mm-hmm.
I'm dealing with safety-related work refusals or complaints. The nice thing today is we got Qualcomm and people that in the major carriers and a lot of the small ones. So, hey, I found, 2 bald tires and an audible air leak. I can't drive this truck. And you put it on the Qualcomm, and they send it back. Do you think you can get it 20 miles down the road? And you send back a message. No, I could, but it's illegal. You need road service. And then you get the dispatcher says, call me on the
Right.
Qualcomm.
Yeah. See,
Okay,
I try
call
to
me.
discourage that.
All right? And it's that point. I agree with Mr. Aronson to an extent about it looking like a setup. But I guess it would depend, it depends circumstantially.
I think less so in a situation where you have that Qualcomm where the dispatcher says, call me, because it can be inferred from that whatever's going to take place in that phone call, they don't want documented in Qualcomm.
I talk to drivers and they will take photographs of the Qualcomm.
Oh, yeah. We like those drivers.
They think that and then I guess my question is, they think that the carrier has editing rights. If they send a message, the carrier can edit it out. And I don't know the technicalities.
I've talked to people at Qualcomm because I've tried to get subpoenas to get this stuff in the past. And it's been a few years. The carrier can't edit them. But Qualcomms are not DOT required records.
Right.
They are not subject to the DOT preservation. So if it went, and I'm not calling out any carriers as bad carriers, and there are bad carriers, but that's not the purpose. Whether it's Hirschbach, Martin, Covenant, Prime, Swift, my understanding from talking to the Qualcomm folks is that they can program whether or not that stuff is going to be destroyed in 2 days or 200 days. Okay? Now, my experience having sued Martin several times for firing drivers because they wouldn't break a safety regulation is that Martin preserves all their Qualcomms. Okay, but it comes in a weird line format.
And oftentimes we don't have access to those when we file the lawsuit,
Yeah.
unless the driver has taken a photo.
Right.
You know, we have
Yeah.
what's called discovery powers later in the lawsuit, where we get to send in a
Document request.
yeah, document request for, you know, any and all communications between the dispatcher and the driver, or whatever the circumstances require. But we don't get those discovery powers until after we've already filed the complaint. So if the driver has photos of the Qualcomm that we can attach to the complaint when we file it, then that expedites our
The
proof.
photos stand up in court, they can't be digitally
Well, altered.
adjusted, altered.
I mean, it's unless there's
I'm
evidence
trying
that's
to deal
been
with
altered.
driver's code, I get from
Yeah,
both
yeah.
directions.
I mean, there would have to be evidence that they were altered. You know, if the company produces a set of Qualcomms and the driver says, well, that's not accurate, and then produces a photo that's date stamped that, you know, where the Qualcomm says something different, then that's going to, it's up to the judge to weigh the credibility of all the evidence. Every witness, every exhibit that's introduced, the judge has to determine how much weight it gets when the judge makes that decision. And if the accuracy of the Qualcomms is called into question for some reason, then the judge is gonna consider that.
You know, sometimes we'll attach the Qualcomm to the complaint. Our complaints go through OSHA. They are our gatekeeper on these STAs and these whistleblower cases. And then we lose there about 97% of the time, same rates as about EEOC. And then we take it to an administrative law judge from the Department of Labor, and they do not apply the federal rules of evidence. They have a looser standard. They have their own rules. They're similar, but they're really loose. There's no jury in those cases that we do, although there is an option to opt out and put it in the federal court, which I don't do, because I do it all over the country, and the judges at the Department of Labor know me. Most of the time, we will not attach certain Qualcomms to the complaint, and we want OSHA. OSHA will say, well, we want to have what you got, and I don't have to get it to OSHA. I'll say, I first want a position statement from the other side and see what they deny, what they say, and then I might whip out the Qualcomm. We have a case going now that's at OSHA against a very large carrier who is, I don't know if they got a booth here, but the company they set up drivers to lease through was here. And the driver was at a truck stop, and he was on a mandatory 10-hour break. And the company said, you need to drive, on the Qualcomm, you need to drive 2 miles down the road to swap out with these guys, to swap out the trailer, because they can't get into this truck stop. They're rookie drivers. And the guy says, I'm on my 10-hour break. And the Qualcomm comes back and essentially says, so what? He says, well, it would be illegal to drive even 2 miles down the road. And the guy had said something, if you drive under 20 miles per hour, it won't show up
Right.
on the e-log. Okay, he says, that would be illegal. And he said, I would break my 14-hour rule. He said, are you asking me to break the law? This is all in Qualcomm. No, I'm asking you to do your job. Okay?
The driver's job is to do it legal, 392.1 and 2.
Okay.
Exactly. So, that is the kind of thing where we might want the company to issue a position statement first before they know what we got.
Right. I just want to qualify one thing, which is on my sneakiness thing, which is, I think it's very different if the company or the dispatcher is calling the driver and has initiated the call, particularly as Paul just outlined, if the company or the dispatcher says something that indicates either that an illegal practice is being requested or harassing conduct, meaning if there's some indication that something wrong is happening or an illegal directive is being given, and then all the driver does is hit a button, I think it's a lot less sneaky or worrisome. If it's reactive and just trying to essentially protect and memorialize illegal conduct, I think I'd say on balance do it.
Okay, all right.
It's a pattern. Just I'm going to go on to the next question, but just very quickly, it's a pattern where they'll send you a message, and then you say something back. I always call it hot potato. they say something to you, and then you have to say something back, and you have to use a magic word like safety, fatigue, something that they know. We talked about this yesterday. Not I'm uncomfortable. It has to be a very specific word that makes them throw the hot potato back, and then you say something like that. Put it on the call, then the phone starts ringing. They don't want to talk anymore. They want to say it verbal, and then you don't take the call. It's like a little cat and mouse game that you have to play all the time. But if you don't have the knowledge to play the game, then you get into this little chasing your tail thing with them. And so, anyway, I'm going to go on to this question: is a 1099 employee for a company who's driving company equipment?
There's no such thing as a 1099 employee. You're either an employee or you're not. 1099s are to report miscellaneous income to independent contractors. Well, and other purposes, So an employee, a so-called employee paid on a 1099 is an employee who should be paid on a W-2.
If you're driving company equipment,
They're paying for the fuel.
Yeah, you don't have the right to refuse a dispatch. Company tells you where to be and when to be there.
Fix
You're an
your
employee.
loads, they cut the invoices, you don't cut an invoice. I see this all the time. I'm a 1099 employee. I said, wow. Most scenarios that drivers call us and say, we're a 1099 employee, would be similar to McDonald's calling the person who works the counter a 1099 independent contractor.
But I think the phrasing of this questioner
They
perfectly captures the problem.
they don't. Yeah, you're driving.
Because they, for all intents and purposes, they're employees. Right. The 1099 is really just a tax device.
It's a method of reporting income.
Yeah, it's a self-serving device for the companies to save money. So they want to control the employee, they want to control the worker, and all they're doing is classifying them in a way that saves the company money. And there's been numerous lawsuits, class actions brought on this called misclassification, huge cases, and it's in a way predatory. And the fact that your employees, and you call you all the time, your clients say I'm a 1099 employee, that's a perfect representation. They are employees, and the 1099 is this artificial, self-serving tax device.
I want to add in that I had a situation in Florida, and I brought it by myself to the Florida unemployment. Remember, Donna? And I went through an appeal process and provided all kinds of documentation to prove that I was an employee and all, and that I didn't win. That I could not get the appeal person to understand the complications of being a truck driver. I'm driving his truck. He's telling me where to get the loads. He is not letting me get loads other places. All of this stuff. I'm an employee. I'm not an independent contractor, and I could not get the state of Florida to get the concept. So it was really difficult to deal with somebody in an agency like that just was like, do you understand what I'm saying?
The duck test usually is effective. What walks like a duck and quacks like a duck is a duck. So if it looks like an employee,
Yeah. Okay, Chemo Sabi. This is a question from Chemo Sabi. Freight claims. Holding pay on drivers due to freight claims. Do shippers and carriers have the right to hold a driver's pay until the freight claims are settled?
The answer is it depends on whether he's an employee or an owner-operator.
He's an owner-operator.
Yes, okay. We have a big part of our practice involves litigation under the DOT's truth in leasing regulations. So the truth in leasing regulations state A, B, C, D, E, F, G, H, and I must be in a lease between an owner-operator and a truck dealer. And it says those things which must be in a lease must be adhered to. Okay? So the DOT's truth and then there's a private right in the statute, the old Interstate Commerce Act, parts that were retained after the ICC was abolished, allows us a private right of action, we call it, to sue to enforce those DOT regulations. Normally you can't sue to enforce a regulation. Congress, when they sunsetted the ICC, allowed us to sue and enforce those regs. The regs essentially say, on the side of deductions, the carrier can't deduct something that you haven't agreed to in the lease may be deducted. Okay, like damages for loss and damage. When the lease has to say you will be responsible for any loss or damage, you might say occurring as a result of one, your negligence, or two, just simply occurring while the load's in your custody. Okay, could be differences. And it says if you're going to get a deduction from your settlement, it has to be documented. Okay, so taking out for a valid freight claim is something they can do. Right? Escrowing, they may not unless the lease says so. Because we have, escrows are allowed under leases. No cap on the amount. So if we're basing, and I'm shooting a little bit from the hip because I haven't had this specific type of question for a while. But to hold pay until the freight claim is settled, probably not. Give the documentation. Now, could they give the documentation and then make an estimate because they haven't resold it? Perhaps, okay? I'm not sure there's an exactly clear question. But just simply saying, hey, we're liable, so you're liable, or we're just going to pay it to keep the shipper happy. No, that doesn't establish liability. A carrier is case law says a carrier is a virtual insurer of the goods. So the shipper is going to recover absent an act of God, an act of the public enemy, an inherent vice in the product, what we call, or an act of the shipper in freedom from negligence by the carrier. So let me give you an example, because I used to do a lot of loss and damage claim seminars when I represented, before I primarily represented drivers. Suppose a driver Joe Jones is driving for fly-by-night carriers, and he goes into a shipper, and he's there to pick up 2 pallets of glass statues of the Blessed Virgin Mary. All right? And they're packed in paper sacks, grocery sacks from Kroger's. All right? And he said, the driver says, Jesus, doesn't look really good, safe way to transport these 2 pallets of glass statues of the Virgin Mary. And the shipper says, oh, drivers do it all the time. It'll be fine. And you go out, it goes around a curve, and they go to smithereens. In that claim situation, the shipper's going to win. Because the case law is the carrier is the person who's in the best position to determine whether or not the goods can be safely transported. And 2, the carrier's not free from negligence. So there may be an act of the shipper that helped this, that caused this, but the carrier has to show its own freedom from negligence. So the carrier is a virtual insurer of the goods, a common carrier, subject to what's called the Carmack Amendment. So, in that same, and then the carrier vicariously passes that off to the owner operator through the lease company. So a lot of this is, what does the lease say? So if they can charge them back if the lease says they can charge them back.
All right, we got 2 more. Dawn, owner operator leasing intermodal. For years been operating without getting rate sheets and has discovered blatant discrepancies in settlements. How should he proceed?
Can I elaborate a little bit? He signed a lease with the carrier. It's in the lease that he will get weekly settlement sheets, but when the drivers would go and ask for their weekly settlement sheets, they were denied. So the driver ultimately ended his contract and went on his way. But other drivers were kind of trapped in that scenario, so they're just hanging on.
So the driver's just getting a check with no documentation as to how that money is
documentation. They don't know if they're being paid properly.
The question is, how should he
percentage, this,
proceed?
that,
He
and
should
that.
call us, but I mean, go ahead.
I think that's what we told him to do.
What he's talking about is he's asking for the rate sheets. He's not asking for his documentation of his pay sheet.
Was he getting a settlement?
Yes, but he's
he was
asking
getting-
for the rate sheet from the shipper to the
Well,
carrier.
Okay, he's not entitled to get the rate sheet. There's a...
Then you're right. There's a misunderstanding
Yeah,
here.
okay. for again, we're talking about an interstate driver. He's
You know, this guy was pretty much throughout Chicago area, maybe, yeah, interstate.
Oh, yeah,
probably
but
even
that's
Milwaukee.
going to be, you know, people misconfuse interstate commerce and interstate transportation can exist when you're hauling from Wheat Ridge, Illinois to Chicago. You have a prior or subsequent move by container.
Right.
On a rail flat car.
International.
So the driver hauling that, there was a whole series of litigation which we and others were involved in the late 80s, early 90s on this. That it, really we're fighting this issue. It's too complicated to explain. So if it's interstate, then it's subject again to the truth in leasing rules. Now, we just talked about what can be deducted. You know, it has to be in the lease and there's got to be documentation from it if you're a leased operator. If you're on the revenue side, the rules say the following. If you are paid on a percentage, which I think most of these port drivers are, right? And they're not getting, some are paid by the hour, but it would certainly be, he wouldn't need
Percentages, probably.
Yeah, okay. Certainly, he wouldn't want the rate sheets if he was paid by the hour. He wouldn't care. The rules say that at or before the time of settlement for those
I believe
drivers,
this guy was what we call an independent. He was running under his own authority because he had contracts with several of these outfits.
Okay. Well,
So the way
let's
he
take that as
stated,
a secondary question. If you are a leased owner operator and you're paid on a percentage, the rules say at or before the time of settlement, the authorized carrier, that's the term the regs use, shall provide to the operator, you know, and if you're paid on a percentage of gross revenue, then the leased operator shall be provided at or before the time of settlement a copy of the rated freight bill, invoice, or a computer-generated document which contains all the same information that would appear on a rated freight bill, but they can put out the customer information. So to me, if your settlement contains all the same information that appears on a rated freight bill, that suffices. Now, to me, if I'm looking at a settlement, though, and I want to look at what's on a rated freight bill, I mean, I'm an old freight guy. I worked for carriers years ago, you know, grew up in it. I typed up freight bills for my dad's trucking company. You know, you either got the rate per mile and the cents and the mathematical extensions or the per hundredweight charges, detention, you know, the pickup location, the destination. For the carrier to comply, your settlement has to have that, or they have to give you a copy of the invoice. 2, the regulations state, regardless of whether you're paid by the hour, miles per day, whatever, they have to afford you the opportunity to review upon reasonable notice the documents used to calculate the rates, which means you tell them, I want to come in and look at your contract with JB Hunt Intermodal. Okay, and I'm not saying, you know, JB Hunt has this whole thing with the railway flat car, okay? I'm not picking on them. I've never sued them, so maybe they're doing something right, okay? So I want to go in and I want to see the rate sheets. I don't care, you're hauling, you know, chickens from Tucum Carrier to Havre, Montana. You get to come in and see the rate sheets. They can block out the customer information. They don't have to give them to you. But if they got a contract with Genio Turkey, you get to see the
that's death to a driver to even ask for that. And that's unwritten rule.
I know.
That's
So
death.
he's found discrepancies.
Yeah, the question is, what are the discrepancies?
He's discovered blatant discrepancies in the settlement.
I don't know
How
what that
should
is.
he proceed?
But
Well,
is he
he-
percentage?
He feels,
He's on percentage.
I don't
he
know, I'm
feels,
asking.
we don't know that, but he feels that he's been wronged and he wants to know how he would proceed.
Well, okay, so this gentleman he and I straightened some things out in the hall. You talked to these guys, right?
Mhm.
Okay, so this dude,
He
he has
feels,
his own authority.
He has his own authority. He's leased on with several different container outfits. He went to this one. The way you don't know if they got the right terminology.
Yeah.
The terminology he uses is the statement, not his pay settlement sheet, but the statement between the carrier and the customer.
Okay, but you said he's leased on to several. Is he hauling
He
as a
says-
subcontractor for several carriers?
Yes.
But he's running under his own authority. His own name's on the door. His company name. he doesn't, I mean.
He's got contracts with several
Okay,
containers.
so if he's, okay.
Right.
I mean, I don't think that, there's no law that I know of that says they gotta send him something. This one needs more information.
Right.
Yeah.
I mean,
It's
if,
very
if I'm a
hard.
carrier and he's a carrier, one truck, he's got his own authority as a
Right.
carrier.
Well,
I mean, he should know what his rates provide.
his number's on here, so if somebody wanted to.
Yeah.
It says how should he proceed, so it sounds like he knows enough to think
Actually,
that he
Casey
has.
Phillips was talking to the guy.
Oh.
I was.
So,
We had two
I gave
radio
you
shows.
guys
The
the-
first radio, they were asking me questions.
It's
And
the
this
Dawn
is from the
question
second
down
one.
here, so, okay, you can follow. So this is gonna be the last question, and then we can wrap this up, and then if anybody wants to talk after we've, let the camera guy go and wrap up the dish, that's fine, or if you have time. Do carriers have the right to throw a driver out on the street? And that came from Pat, and that's kind of a little bit vague, but there's different situations.
I'm
The
a
teen
driver trainer
driving's-
and I don't get along
Yeah.
with you. Can I put you out? I would be a representative of the carrier being the senior driver. But we hear these drivers out, oh, they behave like that, I put them out on the street.
Yeah.
And I'm thinking, you
Yeah.
can't do that.
That sounds like a bunch of truck stop BS, that, that it's like the drivers would call, somebody wanted to cite me for an overweight, and I was gonna tell that scale guy it was wrong, and I got the US Marshals out there to arrest him. There's a lot
Yeah,
of,
right.
lot of trucker fiction.
But
Correct.
I have been put off trucks.
Yeah, but you never got the US Marshal to go and arrest the scale operator.
No.
Yeah, no, I've
So
seen
when you
But there's
put
a
off-
lot of
Look, if
drivers
you-
that feel it's okay to
Right.
You can be put off the truck.
You mean if somebody fires you and they say, okay, get out at this TA in
if they do that. I mean, we've heard of people left out on the side of the road in a snowstorm.
Right.
And it's not your boss, it could be your co-driver, like we
It's
talked
the
about
senior
earlier.
driver of the truck, the first
You have
seat.
an argument in there, and the
Mhm.
person that's the lead seat or whatever they got, they just say, you're out. One girl, quid pro quo,
So
have
it's
sex
just
with
state
me
law.
or you can walk to town, and it's a snowstorm outside, so what are you gonna do? So,
And in this case, you say call the carrier, and it's a weekend, and we have
And
several
they have-
carriers
yeah.
will not answer their phone on the weekends.
they don't answer the phone, there's
Call the
nobody there.
police.
So,
There's, as far as I know, and I've been doing trucking law 32 years, and first 10 mostly carriers, but always have represented drivers some, and now it's like 99% driver work. There's no federal law on this, so for me to give the answer could be different if the driver's abandoned in Nebraska versus whether he or she is thrown out of the truck in Oklahoma. Some states, I am aware, I can't tell you the names, have laws that say they got to pay for your transportation home or safe environment. It's a federal law, so I don't have, unless it's done for a legally impermissible reason, yeah. Like it wouldn't submit to sexual favors or something like that. That's different. Or it wouldn't drive in violation of hours of service. Then there are anti-retaliation laws. But in general, we're not getting the law and I'm putting you out here, get out of my truck. Trainer is usually an owner-operator losing money. Okay?
Exactly. That's how they track them
It's
down.
actually somebody who's been foolish enough to do a lease purchase.
Right.
And is losing money, so
They make him a trainer. Yeah, we see
I know
that all
Prime
the
does
time.
that. They testified that in one of my cases. Why did my client get to be a trainer? She wouldn't drive through Donner Pass in a bad snowstorm and got fired for it, okay? But the question is, why did you make her a trainer? Well, she was losing money.
She was losing money.
She was losing money. Well, why would a trainer make her better? Well, she'd get a second driver in there. I said, how so? You get more miles. I said, isn't she on duty and she's in the right-hand seat training? This was before the little rule change. She said, yeah. I said, well, okay, how do you get the extra benefit of the driver? Well, when the trainer is sleeping. I says, how do you train while you're sleeping? But I'm digressing. There's not a good answer to this question. If it's not for a legally impermissible reason, then it's going to be a state-by-state determination.
Okay.
It sounds crazy that the ability to put a human being out on the road
yeah.
on a highway.
Is inconceivable.
Right, I mean,
Yes.
it sounds like, you don't have to be a lawyer to know that's wrong, right? So either you're saying, so there are some state laws that regulate that?
That says they have to give them make arrangements for the return to the home base of work.
And all companies do not have policies that,
Not
No.
really.
No.
I mean,
It's
there's
really
some
random.
big ones. The
It's
big
really
ones
random.
do. They don't, the big ones do. I mean, I
We get
name
calls all
names
the
on that,
time.
but
Yeah, they
but-
put you on a bus and then they withhold that out of your final check.
Or they
Hold it at the
withhold
final
the
check, but
personal
sometimes
equipment.
they won't even return. Once they know that you're off the truck and the person's left you there, they're either not there for the weekend, like she said, or they stop taking your calls.
But if this-
Especially if you're not on any of their property. Now, if you got left off at one of their remote satellite terminals, they might take your call when they get around to it. But if you got left at something that's not any kind of property, where you're just at the Walmart parking lot or something and you're in Nebraska but you live in Florida, they'll stop taking your calls.
wouldn't the companies be concerned that, poor ejected driver is now on the highway, is trying to get to off an exit, gets hit by a car,
Right.
paraplegic, sues the company for negligence because the company didn't prohibit this, and has a $20 million liability because this person can never walk again.
See,
They
that's
don't
my
think
whole
that
statement.
out.
But
They
through
don't
their
think, there's too many of the drivers that enter these situations that they have no resources at all
None.
to ever be seen or heard from ever again. And they always gamble on that, these companies that do
It's
this.
very exploitative.
Yeah, now, to their credit, the big company, we know who the majors are. We know a lot of people who are here. They have those, I mean, I've seen, they have those policies of at least getting them to a terminal, and they'll give them a bus ticket home, which might take 4 days on the Greyhound. They have that.
But even
Well,
some
that
of the
would be
big
the
companies
proper
will
way to
play
do
the
it.
game.
Martin does that.
Yeah, that
They
would be a
fire
proper
people
way
on
to
the road,
company
they give them a
facility.
bus
Yeah.
ticket home.
Some do, but I mean, there's some there's some big companies that don't do it the right way. It's really
You're out of the truck and your personal equipment's in the truck.
the
and you don't
onus
get
is
it
on
back.
the individual
Got my student at
to
hotel.
play. Like I'll tell women, don't get off the. Make them take you to a terminal. Don't get off anywhere, and don't tell them that you're going home, because then they'll stop taking your calls. Like when you want to get in your back with your training and stuff, you want to make sure that you're on their clock still. Make them take you to a terminal. Don't let them leave you at a truck stop, because they'll stop taking your calls.
They will.
They won't give you a Greyhound bus ticket. So, but if you're on their property, at one of their satellite terminals, it might take them a while to deal with you, but you're under their roof and they know it, and they know they got to do something.
Most of the time when we get the phone calls, it's after the fact.
But yeah.
I'm at the truck stop, he's got my phone, he's got my
Yeah.
purse, he's got my clothes, whatever.
And you're not getting those back.
Yeah.
No, they got missing.
Your property,
And the
I mean-
company doesn't send it back.
No.
They're not gonna pack your stuff for you.
No.
I mean, I even tell those drivers who are solo, they threw me out and they got, $2,200 worth of stuff. Well, that might be the retail value. Well, we see this all the time. They have my TV, my refrigerator, all my clothes, I mean, it's tough. But they don't have to give, they can hold it for a little while and say, come get it. Well, nobody's got any money when they've been illegal.
Okay.
Nice to meet you.
Okay, are we adjourning?
Oh yeah. You can stay and talk. He's got to catch his flight, and I'm gonna get upstairs for our next thing. Thank you so much.